Red Armela Research Group. Before giving the floor to Professor Nogueira, who's going to introduce our two speakers, I would like just to say a few words on the research group and also our current research project. Red Armela is a research group of the University of Santiago de Compostela. It was created in 2012 and is led by Professor Nogueira. It embraces an interdisciplinary approach with insights from public law, constitutional law, and political science, and has developed a research agenda on social rights, the welfare state, and also gender equality. We have an extensive experience of collaborating with researchers from other universities and more intensively with our colleagues from the University of Vigo, who just arrived. Currently, we are developing a new research agenda on the impact of digitalization on social rights, social policies, and public administrations in Spain. To do so, we got funding from the National Agency on Research in order to develop a project called Vulnerability, Social Rights, and Public Administration. COVID-19 represented a big external shock for public administrations in Spain and elsewhere. That shock can potentially increase situations of vulnerability due to the quick introduction of digital public services in many contexts. However, it can also represent an opportunity to expand social rights. Our project wants to delve into these two possible scenarios, and it has three main goals. First, it explores the evolution of the welfare state and the potential consolidation of new social rights that were initially introduced to respond to the pandemic in Spain. Secondly, it also delves on the transformation of public administrations to deal with this emergency. It seeks to analyze whether digitalization and changes in administrative processes might have led to greater levels of vulnerability for some social groups. And finally, adopting a gender perspective, which has been at the core of our research agenda for a long time. We also focus on the consequences of digitalization and the prevalence of non-face-to-face public services in the situation of women as a vulnerable group. These three goals are very much in line with the research agenda that both Andrés and Michel are developing at the moment. So we do think that this research seminar is going to be very interesting for building synergies and collaboration between our projects. Thank you, and I'll give the floor to Alba, who's going to introduce the two speakers.
Okay, well, good morning everyone. Also for those who follow us in Teams from different universities. Hope the online version is almost as good as being here, although you won't have coffee. We are in touch. Alba Alonso has just presented the object of the project we are working on. The seminar wants to contribute to the objectives of this project by studying to what extent the use of algorithms can help to analyze law, and particularly housing rights and evictions, in the case of Michel Vols, and the problems of transparency of algorithmic decisions on vulnerable groups. We have with us two of the most relevant scholars working on this topic. Michel Vols is full professor of the University of Groningen, and he holds an ERC starting grant, which is not very usual in law, so that's great. He is the principal investigator of the BIG project, and he leads which adopts a unique data-driven approach, combining traditional legal methods with data science techniques to conceptualize the right to housing and to find and explain predictors of court decisions. And we met Michel leading the tenant law group at the European Network of Housing Rights, and some members of our team have shared with him several conferences and publications, so it's really nice having him here today because we have a long-lasting relationship. And we also have Andrés Boix. He is an administrative law academic from the University of Valencia. He leads a project on algorithmic law, which we are part of. Andrés was one of the first Spanish scholars to write on algorithmic decisions, and he's here to explain us how the guarantees we have from administrative decision on real life are the same when we use algorithmic environment. So we hope you enjoy the seminar, and the floor is yours, Michel.
Thank you so much. You can show my presentation and share it to the people live. So thanks so much for being here, and thanks so much for organizing this workshop. It's fascinating to be here in Santiago. It's a beautiful town, and also good to be abroad after such a long time of pandemic and COVID. So, as Alba described, I'm Michel Vols, working at the University of Groningen, which is up north in the Netherlands. It's an old university, not that old as your university, so you beat us. But it's also around like 450 years old, a big research university. I have a background in law, so I studied public law. I did a research master over there and a PhD, and some background in political philosophy. So that's why I like this project, this interdisciplinary project. And I like your project a lot because it's much needed that we need to do interdisciplinary research and also look at vulnerable people in law, because I think most of the law schools are also focusing on business and stuff like that, so a kind of counterbalance is good. As Alba already said, so I'm heading this EVICT project, which is funded by the European Research Council. Very lucky, so as you said, it's not common in law, but you just need to be lucky as well. So you need to work hard, of course, but it's also a question of luck. I will tell you something more about the project and the data-driven approach in a minute. But basically the question we want to address is how the right to housing helps people stay in their home during the economic crisis or any crisis. When I wrote the proposal, we knew about the financial crisis, the economic crisis you also experienced in Spain, of course. And now there's a new crisis, or there are two new crises, namely refugee crisis because of the wars, but also the COVID crisis, so it's a health crisis. And it all had impact on housing rights, right? So, and you know for sure in Spain a lot of people lost their home during this crisis. What we want to know is, did the right to housing help, and why did it help, and why didn't it help? Because we know often it doesn't help. That's the more legal perspective in the project. What makes the project special, I guess, is that we use, as Alba said, traditional legal research methods, human rights research, finding out how the law reads, how it interacts, what's the case law. We combine it with data science. So in the team, we have a big team. I just told you we have 4 people, data scientists, working full time to study legal data. What do I mean with legal data? That's just case law. There's a lot of case law, and that's why the evictions are that interesting, because there are that much eviction. There are many evictions. Only in the Netherlands there are 30,000 cases of evictions each year in landlord-tenant law. And the Netherlands only has 50 million people, or 60 million people. In Spain there's much more. In the States there are even more. There are also on international levels, there is a lot of case law, the European Court of Human Rights. So there is a lot of data, but we as lawyers tend to only analyze them manually. So we read them one by one. And that's of course impossible because there's too much. So therefore we don't study them, or only a limited group of, or a limited part of the case law, and we can only study them in our own language. Like you cannot study the Dutch case law, I cannot study the Spanish case law. And with using data science, we can help lawyers to study that data. And today I'm not going to delve into all the eviction case law, right? So, but I will give you an overview of automatic prediction of court decisions. So that's a big topic, I guess, also for the next speaker. Can we use algorithms to predict the decisions of judges? Of course, that's scary, because we don't want a robot judge. I'm not in favor of a robot judge, and I will show you that the people that say that they're building this robot judge are over-promising and are actually not building a robot judge. They cannot build a robot judge. And if they claim that they will build a robot judge, we should be very skeptical and also critical about that, because it's bad if you use these techniques to use them. But still, I think the techniques are promising and can learn us something as lawyers about the case law. My title of my presentation is Rethinking the Field of Automatic Prediction of Court Decisions. So I'm going to look at how can we predict court decisions. We mainly looked at European Court of Human Rights because it has a binary decision. So there is a violation of a right or there is no violation of a right. Or there is inadmissibility, but then in the end the court rules that there is no violation of a right. But we also looked at housing law cases, eviction cases, national cases, and we actually predicted the future as well. I will just give you, if you think, oh, I don't get what he's talking about, that will come in a minute, right? So, but first, if you want to ask questions during the presentation, feel free to do so if you allow. So if you, because it can be, okay, maybe you're not very strict. But if you think this is not clear or this is very technical or I want to know how you did this, please let me know. And please, for the chairs, just say stop, because I didn't know how long I can talk. So if you think this is enough, just let me know and then I will stop talking, right?
Until your playlist.
Exactly. So, but if you think this is going to be boring, just let me know, right? Okay, let's go to the next presentation. So feel free. This is actually not working. Maybe I see to. No, it's on. We're not. Oh, there. Yeah, that's also.
We'll give you the floor.
That's okay. Let's see. This is also not working.
Oh my god.
Yeah, it's gonna be hard.
So maybe Andre, you can push
Yeah,
No, but on the screens, they're not changing.
No.
In the lower screen, it is changing.
Yeah, but not in the video.
So this is the Teams that.
So maybe you can just use the arrows or the. Yeah, exactly. So that's basically. If you want to know more about the methodology, I just published a book last year. It's in English about methodology in law. So where we explained what's traditional legal methodology, because I think that's an issue with lawyers. Usually when we speak to non-lawyers, sorry for pointing to you, you don't have a clue what we're actually doing, right? So we're reading case law and then being critical about that, but what's the actual method we're using? I think we actually use methods and that we're proper scientific discipline, but we're actually quite bad at explaining what we're doing. And I think that's also what makes us lawyers being not getting that much research funding, because we're quite bad at explaining what we're doing. And we should be proud of what we're doing. So that's why I wrote this little book. It's a student manual, but it's also interesting. You can but there's also more about data science. And then if you want to know more about the EVIC project, just go to the website. We have everything explained and some publications over there. If you go to the next slide. So this is basically the big deal. If you've read all the stuff about predicting court decisions, we building this robot judge, we're good at building, and it's a hype. That's also what you show over here. So here we have all the publications that are claiming to predict court decisions over the last 4 or 5 years. In 2021, there are even more, right? So that's. It all started with this Aletras paper. It was even on the BBC Newsline, where it says, we built this robot judge predicting the court decisions of the European Court of Human Rights. 80% accuracy, 90% accuracy, meaning that in 80% or 90% they were right. Then we had like a lot of other papers, including our own, right? So in 2019 we published Medvedeva et al., that's me, but with the data scientists in my team, so I am the et al. That's a story of my life, probably. But we also see some Chinese scholars predicting whether someone gets a death penalty in China. They're quite good at that, and they even said so. We should use this algorithm to maybe prioritize cases. To see which people are more likely to get the death penalty and then they can go to court earlier. Quite scary, I guess, especially if you see what they're actually doing. I think it will be very, very bad if we use that type of techniques, but they're all claiming to predict court decision. There are also cases about the French Constitutional Court. I've not seen Spanish cases yet, but probably there will be, because there's case law online and yeah, you can claim to predict. So okay, this is the research, and I put a little asterisk or a little star behind the predicting court decisions, because my main point is that they're not predicting court decisions. They're doing other things. which is scary if you think that some people say we should use this in real life. We go to the next slide. You see what we did. So there is this paper called Using Machine Learning to Predict Decisions of the European Court of Human Rights. So that's Masha, which is a data scientist, that's me, and Martijn Duding, who's a professor of computational linguistics, which is who's on our team. In this project, we predicted, or we claimed that we predicted, because now if I look back at our own paper, maybe prediction is not the best word. What we did is predict the court decisions of the Court of European Human Rights. It's published in Artificial Intelligence and Law, and it's all publicly available. So if you just Google it, you can just download it. And we made an effort to make it understandable for non-technical people as well, right? So if you don't have a background in data scientist or data science, probably you can understand, because we actually explain what's machine learning, how do we use it, what's the algorithm, how did we download it, how do you interpret this result. So, and it's now used in many law schools around the world just as an introduction to this. And I think that also shows why interdisciplinary research is that important, because I didn't have a background in data science or data science. Now I know something about the data science approach, but it should be understood. If I don't understand it, and probably other people don't understand it as well, and then maybe the paper is not that interesting for the legal community. Okay, so we use this machine learning techniques to predict the decision of the European Court. So if we go to the next slide, you see what we did. Okay, now we start with numbers, and I know for lawyers that's maybe not the thing you're familiar with, but I will try to guide you through the math. So this is the table. So here you see Article 3, Article 6, Article 8. Probably you're all familiar with that, right? Article 3 is the prohibition of torture. Article 6, the right to a fair trial. Article 8 is the right to respect for private life, family life, and home, and correspondence, and so on. So then we had like a number of cases that we analyzed. So there's a whole, I'm not going to delve into that, but you cannot just look at all the cases of the European Court and then do machine learning and then say I can predict. Because you know, like if you go to the European Court, first there is the admissibility stage. If you pass the admissibility stage, 80% of the cases will result in a violation. So if you ask me, what do you predict as a human? If I know that a case is admissible, I will always say, oh, it's a violation. I will be right in 80% of the cases. So if you see people claiming predicting court decision using machine learning, and they say, I have 80% accuracy, it's actually not that bad. Right? So because as a human, you can just, without even looking at the case, you know 80% rule. So what you first always should check, whether they used a balanced data set. That means that you cannot just put all the cases in this black box of the algorithm, but you should balance it. So you should make your data set, and that also implies something where I will tell you something what makes it, that it's also causing some problem. You should always have in your training data set, where you train the machine to predict, as much as, or as many as violation cases or non-violation cases. Because then you have the baseline at 50%. And that's the same as chance. Right? So you know that, well, it can be violation or non-violation. So you cannot use all the cases in your data set. So therefore you see, because there are hundreds or thousands of cases on Article 6, but still most of them are violations. So if we train the machine with only violation, then the machine will only say violation all the time, and it's right in 80% of the cases. So therefore they can only use 900 cases to train the machine. So therefore there's this number of cases that differs. So with the 900 cases we used the system on, we looked at 3 different things. So what we did first is we looked at the judgment of the European Court of Human Rights. And probably you know the structure of the European Court of Human Rights, how it did. First they describe, so who's on the bench, right? So who are the judges? Then they describe the facts. Then they say, so there's this article that the applicant complains about. And then they have this section, the law, and they do the legal reasoning, right? The court says, so there's to one judge says there's a violation and so on. So only the conclusion. They left that out because if you leave that in, the computer will just find that sentence and will predict it. So it makes sense to leave that out. Aletras left everything in that's above that conclusion. But when you look at the judgment of the European Court of Human Rights, in their legal reasoning, they also say so therefore we believe there is a violation of Article 8, or therefore we believe that there is a violation of Article 6. So what Aletras did, they looked at all the text in the case, in the judgment, but they basically cheated, because the conclusion is already in this part. So basically they asked the computer, find this sentence, and if you find that sentence, the computer will say it's a violation. Basically, they just identified the judgment in the decision. So what we did, we only looked at the facts. So we excluded almost everything from the judgment, and we only looked at the facts. So therefore, then it says, so this person, this is Santiago de Compostela, and then the government came and searched his home, and he thinks it's a violation of Article 8. That's it. And with that information, we asked the computer to predict, or the algorithm to predict the outcome. What we find is, we did it in Article 3, in 80% of the cases it was correct, it was accurate. In 80% of the cases in Article 6, and in 72% of the cases, it was correct with respect to Article 8. So we see on average it's 77%. So it's almost as high as Aletras. Aletras is somewhat higher, so the BBC headline, but we think they cheated, because the answer is already in their data, right? So that's not fair. What's interesting is that Article 3 is much more easy, or it's better, we can predict better on Article 3 than on Article 8. So anyone who has a clue why is that? Does anyone know? So,
There are not so many violations and then the database.
yeah, so that might, but this is a balanced data set. So here the point is, so maybe the data is different, right? So there are more violations or less violations. That's not the case. But just think about, like, Article 3, they're very straightforward cases, right? So there is someone being tortured or not, or being put in prison often, right? So without any light or social activities, and then they say this is torture. So they're pretty straightforward cases. They're always about prisons or like very bad governments actually, or police officers torturing. Article 8, it's a very broad range of cases. There are the eviction cases, of course, but there are also the LGBTQI people that want to have their rights before a marriage or something. There are also other type of marriage cases, right? So there's private law cases about noise nuisance living next to the environmental. So that's the range of topics is quite different than Article 3 or Article 6, where you just can decide this is a fair trial, there was a hearing or not. And in Article 8, it's more diverse. And it also changes a lot, right? So if you look at case law from the 1980s, then the right to correspondence will be about the government entering into or looking into someone's mailbox, a physical mailbox, checking the letter, opening it, and then closing it again. And right, so they're doing the things that governments do. If we look at that at this moment, probably the government is not going to check your physical mailbox. It will use probably an algorithm to hack your computer and check your mailbox, your email box. So that also changes, right? So there's much more development in the interpretation of the concepts of the European Convention. And therefore, I think that's my hypothesis, that Article 8 is much more difficult to predict. But still 72%, actually quite good, right? Then future cases, what do I mean with that? So then we try to build the algorithm with older cases, like for example, cases from 2013 to 2018. And that was our training set, where we trained the algorithm with. I can explain what I mean with training, because maybe that's somewhat different. So first we download all the cases from HUDOC, which is the system of the European Court of Human Rights. Probably you're familiar with that. Within the HUDOC system, so we have 10,000 of cases. There is metadata available on HUDOC. So it says within this case, McDonald versus UK,
The judgment is violation. It's about Article 8, and it's a UK case. It's a case about UK. So we have this data set where we just have names of the case and numbers of the case and the judgment. So then we need to make a balanced data set, right? And we separate, or we divide the data set into different groups. Namely, a training set and a test set, and some other test set we can use for other tests, right? So we separate a training set from a test set. The training set we're using to train the algorithm, to make the machine, to learn the machine something. And then if we learn the machine something, then we give it a test set and we test whether it learned it in a correct way. Does it make sense? So the training set, how do we train the computer? It sounds very difficult, but it's actually not that difficult. What we do is, we give the computer a case, and it looks at all the words in the case. So it has all different words, right? So and we can say, so look at the words like a unigram or a bigram. What does it mean? A bigram is 2 words. Oh, yeah. So if a sentence reads like this, the dog walks in the garden, then a bigram will be the dog, but also dog walks in garden, or in the garden. Does it make sense? So that's a bigram. Trigrams is the dog walks in. Right? So it just gets that type of information out of the case log. And we give the computer the outcome of the case. So we say, so this is all the words that are in the case, and this outcome is associated to this outcome. Dog walks in, stuff like that. And then it tries to find the combination, so common combinations. And we even can learn the computer to leave out certain words. So things like the, or right, or like common words, we leave it out, so it ignores them. So it finds word combinations that are associated to the outcome of the court, of the judgment. So we know that dog walks is associated with violation, and Santiago de is associated to non-violation. Just an example, right? So we train it, and we train it like 100,000 times, because there's a lot of data. There are many words in this. So we train it, and we train it, and we train it. Then we have a good algorithm, and we use that algorithm to analyze the test set. So, and with the test set, we only give it the words. So we only give it dog walks, or Santiago de, or Spain, beautiful, right? So things like that. And then we ask the computer, can you predict whether it's a violation or not? And we know whether it's a violation or not, because we have the answer, but we just check whether the computer is correct. And then we can check the accuracy. Right? So that's basically the machine learning thing. So it's not very difficult. Of course, you need to know how this system works, but it's just a standard system. You just need to give it the correct data. And don't forget to leave things out, as Aletras did. So the much hyped is where basically already in the data is violation of, or violation of Article 8. If the computer just sees these words, it will automatically predict the violation. So we only give it effects. With future cases, we used the old cases for the training set, 2013 to 2016, and in the test set, we only used new cases. So we gave it new cases from 2021 and 2022, or in this case, 2020 to 2021. Not sure, but you see the point, right? So we use old cases and we use new cases for the training. And then we see that it's much more difficult. So we see lower accuracy results. So that learns us that you cannot build this algorithm and then leave it as it is, because then your scores will get worse and worse and worse and worse. Why is that? Because law evaluates, right? So it evolves. Law changes. As I said, 20 years ago, LGBTQI, sorry for mispronouncing all the words, but the gay community, right? It was not a big topic in European case law. Now, of course, it is, right? So they go to Strasbourg and they say, so I have a right to private life, I have the right to change my name or change my gender. If we use old data sets, all these cases will result in very good predictors, but still, we find that the best predictor for violation in cases about Article 3, about torture, is the words condition detention. That's the thing. And the second one is applicant transferred. It makes sense to me, probably it's about like prisoners being in a detention center or they're transferred to somewhere else and being tortured over there, but it doesn't learn me a lot, right? So still they're good predictors, but if you say we're going to build a robot judge, with these words, so then someone should say to a judge, conditions detention, and then the judge will say violation. It doesn't make sense, right? So we can predict and we can see that these are the words that are associated to it, but it doesn't make sense. So and the same with non-violation. Then July 1989. That's something I don't know why. Maybe might be the case that their war happened over there, right? So that there was something like that. Or fourth applicant. So if you're the fourth applicant, then you have a good. It doesn't make sense. Still, they're good predictors. And this is a very simple algorithm we use. So we can, and I will show you in a minute, we can use more developed algorithm. But this is the best there is at the moment, right? So this is the stage we're at in predicting court decisions. So if you have a fancy company in Spain that is saying, we can predict your court decisions, don't buy it, right? So we even had like Ernst & Young, which is a big tax advice, probably you have them in Spain as well. They now built a type of thing in the Netherlands, and they said, so put your complaint in this text box, and then we can say whether you have a valid case or winning your case or not. But they said, please use the wording that is associated with violation or non-violation of your tax rights in this text. It doesn't make sense, right? The court is not going to look at the exact wording and then you have a bigger chance of winning. It's actually about the legal substantiveness about your complaint, not about whether you use the right words. Of course, it matters a bit, but you're not actually going to win in this respect. Okay, but this is the prediction in text. Okay, if you go to the next slide, please say me. Tell me if I'm talking too long, right? So, okay, then, as I said, so this paper is well received. It's like cited over 140 times in a year. Everybody says, so this is very clear. So we were happy with it, right? So I'm still proud of the paper. But still, when we thought about it later on, and we used the word prediction, is this really predicting? Basically, what we're doing is we're having this text, we already know what's the outcome of the text, and then we're going to ask the computer, can you find us the outcome of the text again? Right? So that's not really predicting. It's not like if you're predicting or forecasting the weather. So probably if you watch the television or you go online and you know today or tomorrow is going to be as sunny as today, is it going to be a beautiful day? That's forecasting. Or the same thing, we know that there's an interesting case coming up at the Supreme Court of Spain in the next month. I want to know what the court will do. Will it decide that it's a violation of the Constitution or not? That's the thing we're interested in lawyers. Maybe not whether the Constitutional Court judgment last week, was it a violation or not? Yeah, we can just look it up, right? So we go to the last line and then find it. But still, we call it prediction. We call this prediction. And that has to do with also with an interdisciplinary thing. Within data science, it's common to use the word prediction. Right? So you predict, you have the computer to predict what class the judgment is in. But as a lawyer, we don't use the word prediction in this respect. So therefore, we look at this section info, procedure, and facts. We don't look at the law, verdict, and dissenting opinions. We say what type of judgment is this, and we call it prediction. We don't believe it's right to call that prediction. So why do we keep calling it prediction? And when we stopped thinking about that, we came to a new type of taxonomy, right? So a type of language we use to use this machine learning techniques to study case law. And I think this will be interesting for your project as well, because we have now, as I said, a number of data scientists that are looking into UK case law, Dutch case law, European case law, but it might be interesting to look at Spanish case law as well, because I understand that Spain is the number one of making, in Europe, of making case law online available. Not everything is available yet, but Spain is doing the best, or is doing best, right? So that's interesting, it's an interesting country to look at. So how can we use this type of data science techniques, and can we use this to study Spanish case law as well? So if you go to the next slide, when we thought about like how can we use prediction or machine learning techniques, we think there are 3 types of tasks we can use. And it might be interesting for you to think, so what type of task might be interesting for me in my research? And we can just discuss later on, right? So how can we use this in the Spanish context or at your European, or any other types of textual data. So also for political science, maybe you're not interested in case law, but there are other types of text you want to study. The first stage, or the first task, is the identification task. Maybe it sounds boring, but it's not. It's very, very useful, I think. But more from an intellectual point of view, maybe it's not the most interesting thing. What it basically is, you want the computer to identify the verdict, so the outcome of the case, violation or not, violation of the Constitution or not, eviction or not, within the full text of the judgment. So we just have the whole text of the judgment. We want the computer to identify what's the verdict of the judge. And within the full text of the judgment, we include everything. So it doesn't matter if we leave the conclusion in. So why is this useful? Suppose that you're interested in eviction cases in the Netherlands. There are 30,000 of them every year. They're not published at all yet. Now we only publish around 10% of all the case law. But in future, everything will be published, right? So probably in Spain as well, in 20 years time, everything will be just online on a public database. So then you, as a lawyer and as a law student, you need to go to the website. In the Netherlands, it's Rechtspraakpunt. Probably you have a Spanish website as well where you can find all case law. You find millions of cases. So probably you don't, there's too much data. It's like a tsunami of data coming at you. And you're there as a scholar, how do I find the interesting cases? I'm only, for this project, only interested in eviction cases. Maybe with cases that were referring to European law in Galicia using the Child Rights Convention. Of course, you can just try to Google a search and use, but probably you don't find all the, there should be easier ways of doing that. And we can use this identification task to do that. So basically, we have the computer find and give extra data to the text. So we have, suppose, so my ideal is, you go to the website, you just click, I want all cases about eviction, where there is a European component, where social rights play a role, child's rights play a role, and where the court rules non-eviction in Galicia. And you have all the cases. And now you're unable to do that because there's too much data and we don't know which cases are about eviction, because probably now we need to have like research assistants looking at all the cases and then giving extra data. They're actually doing, a lot of people in my team are actually doing that right now, right? So they're reading all the cases and then giving all kind of extra data, which is extremely time consuming and expensive. And we want the computer to be able to do that. So we managed to do that. If you go to the next slide, and I think, I'll first explain, but I already did that. So we, for example, we were just interested in finding the verdict in the case. So we're not excluding everything, finding the verdict. Just building this better data set. Yeah, so if you go to the next slide. We can use Control F, the search function, just looking, right? So sometimes that's easy. We can make it automatic, right? So we don't need to do that ourselves, but we can just have the computer search for specific terms. And even that works, right? So, but sometimes we can use machine learning to do that as well. If you go to the next slide, we actually did that. It's a very new paper. We published it 2 months ago, where we looked at the Dutch, and I think that would be very interesting to explore with your research team, whether we can do the same in Spain. Maybe on evictions, maybe on other type of cases where there is some case law, right? So there needs to be some, so 2 cases is not enough. Probably a few hundred should be available, but if we can do the same thing in Spain. What did we do? We looked at the website of the Dutch court system, the judiciary, and we wanted to know which cases are about evictions. So first we asked the computer, can you find us all the cases that are dealing with evictions? And then, so within the 100,000 of cases, can you automatically detect them? And if you find them, can you determine whether the court decides whether it's an eviction, whether the person should be evicted or not. Most cases are about landlord-tenant law, people that don't pay their rent, right? So they're evicted. But it can also be squatters. I know that's an issue now in Spain as well, right? So where squatters enter the building and they should be evicted because the property owner says they need to go out. Or where mortgage people that are living in owner-occupied accommodation, and that's the case I think mostly in Spain, where people don't pay for their mortgage and then they're evicted. In the Netherlands you need to go to a court. I'm not sure about Spain, but still you can have that. So what we found is that's in the, above. So we found you need to look at the F1 score. I'm not going to explain you all the different. So these are different types of accuracy, because accuracy is not the only thing you need to look at. The F1 is the better score to see how good the system is. In 87% or 89%, the computer was able to find the right case. So then we automatically, we didn't use the Control F, so we also used Control F. It was actually quite good, but the machine learning system was better. We found more cases. So we had 87%, 89% that we automatically built. And then in the table 10, in 88% of the non-eviction cases, the computer was right in finding the judgment. And in the eviction case, even higher, 94%. So therefore, with just building the system and running it, we identified like thousands of interesting cases among the 10,000, 100,000 of all cases, where we can now have a closer looking, and then, for example, build more interesting data sets. We have the things in, for example, the United States of America, where we have the Supreme Court data sets. A lot of political scientists use that, because there we see that this judge is associated to the Conservative Party or the Republican Party, and this one is a Democratic Party nominee, so we know they're left-wing or right-wing, and we can predict. And we have a data set on the European Court of Human Rights, but we don't have this national law case. Right, so you don't have a Spanish data set where we can have a look at all administrative law cases or all administrative housing law cases or whatever type of case. But we're able to do that. We can build that. As I said, from an intellectual point of view, it's not that interesting. Now we know these cases about housing law, this case is about eviction. It doesn't explain why, it doesn't give any extra information. So it's just our starting point as lawyers to start with the data. So it's not that this is the thing that you want to do all day, but it's, if you have the data set available, then you can do very interesting things, right? So you can find all Galician cases that refer to European law, all environmental cases that refer to this specific judgment, all cases where there are vulnerable people, gender can play a role. We can just train a computer to build this very good data set without looking at it manually. And we can even, what we want to do now is, can we find that cases that are referring to European case law in Spain and in the Netherlands, do they refer to the same cases? Probably then they're the same type of cases. And we can, of course, I can understand some Spanish, but we can also do this in Bulgarian or Romanian or in Ukrainian, right? So we don't need to learn the language, but we can find similarities and then have that case translated, for example. Okay, this is identification. So that's the first task. The second task, and there are three, so sorry for boring you too much, but there are too much. Just say if I need to stop, right? Classification, that's the task of sorting out judgments based on their outcome, violation, non-violation, eviction, non-violation, using textual or any other information published within the final judgment, but excluding references to the verdict in the judgment. It's a difficult definition, but basically this is what we did in our paper that I explained, with the judge's future and stuff like that. We excluded any references to the outcome, violation, non-violation, looked at all the text, dog walks, Santiago de Stay Beautiful, and then we sorted them, basically. Right, so we said, so we're not going to look at we are not cheating, we're not just identifying the outcome, we are leaving that out, but we want to have the computer sort the case law. Right, so that's what we did in the paper. Why do you want to do that? Why is that interesting? If you already have the outcome, why do you want to do that? And I think that's, from an intellectual perspective, is very interesting. Why? Because then you can build this data set, so you can predict, right? So as we did. But the prediction is not in itself very interesting, because why do we want the computer to sort cases? What we want to do is build the accuracy, or have the accuracy as high as possible, so we have a good sorting machine, basically. If we have a good sorting machine, then we can have a look at the predictors. And the predictors are far more interesting than the practical use of the sorting machine. The predictors are things as dog walks, Spain beautiful. They don't make that much sense, but these are very basic predictors. We can also have things like gender of the judge, or is there any reference to European case law or not? Does it make a difference in the outcome? We can have a look at whole sentences or whole paragraphs, maybe even name of the lawyer. Right? So we can make, as lawyers, make sense of the predictors. And I think that's where the interdisciplinary work comes in. We can have the data scientists find the best predictors, but they don't have a clue why this is why. If there's a predictor, Article 8, it's a good predictor. They don't have a clue what that's about, right? So, but as a lawyer, we can see, oh, Article 8, I understand why that's a good predictor. Or I see that a female judge is more lenient than a male judge. That's also where political science comes in. Or I can see that this country or this type of regime that is being complained about is being associated to violation or not. I can make sense of it. We can use our theoretical lens to understand that. So with categories classification, we just classify cases. Maybe it's not predicting, right? So we already know the outcome, but we want to know what type of information does the computer find to be a good predictor again. And that's what we want to do in the evict project. We can see in the eviction cases, we are interested, what are the predictors for a judge to evict someone or not? And if we find, for example, that the words tenant has a child is a good predictor for non-eviction, that might be interesting. Or Article 8 European Convention on Human Rights is a good predictor or not for the outcome. It gives us a clue whether the right to housing is really effective or not. It doesn't give a conclusive answer. We need to look at the context and stuff like that. But it gives us extra information that we only get from traditional doctrinal legal research. Okay, so this is classification. So we look at the court info, procedure, facts, but not look at the arguments of the court or the verdict. Okay. So I already gave you an example with the paper I just discussed. I'm still happy with the paper, but if we had to give it a new title, I would not use the word prediction. So that's just our own development of our own thoughts, right? So we're critical about our own thing. Maybe then it doesn't get cited a lot because people, if you say categorizing or classifying in case, people don't find it. So now it makes sense. But if we need to rewrite the paper, we should act this. We also read a paper about this presentation, so we said so we should rephrase our own promise. Then this is the last. If you go to the last category, and it will take around 10 minutes, right? So if that's okay with you. That's forecasting. It's basically forecasting the weather. Then we want to determine the verdict of a court on basis of textual information about the court which was available before the verdict was made public. So we know, for example, in 3 weeks' time, the Spanish Constitutional Court will rule in this specific case. It's Galicia against the national government, or well, I don't know how it works, but probably that's the case. And Galicia introduced rent control, and they're not allowed to do that according to the Spanish national government. We know that these judges are on the bench, and we know we know a text that the government of Spain produced to complain about the rent control in Galicia. We don't know the answer. We can, of course, make an educated guess because we're law professors, right? So we say, okay, probably they will win, probably they don't win. But we can also ask the computer to do that. So we can, for example, look at the composition of the courts or text of other legal documents. So basically, in the training phase, we don't use the text of the judgment. We use the outcome of some previous judgment, but we give it other text or information than the text of the judgment. So we said, so these courts are, these judges are on the board or in the court, or we know that it's about Galicia, so we give it the word Galicia or Catalonia or whatever. Difficulty is that we don't have that much data, right? So in most cases, we don't have, for example, if you look at administrative law, we don't know about the complaints about the people that complain about the decision of the government, right? These are not public, so it's difficult to sometimes find this information, the data. But in some cases we do. For example, in the US, and that's where the political science comes in, we have this data set about judges, right? We know that Judge Kavanaugh in the Supreme Court is a Trump friend, so probably he will be right-wing. And we knew that the new appointed judge, the newly, I don't know her name, but she is appointed by Joe Biden, so probably she will be left-wing, right? A liberal. Maybe in Spain that's the case, you know which judges are right-wing or left-wing. In the Netherlands we don't have, or we're not supposed to have political appointments. So there's no, we cannot have a clue, probably they're more liberal left-wing and they're not that right-wing, but still, we don't know. They're supposed to be independent. And the same thing in the Netherlands, the Supreme Court just gives one ruling, so we don't know which judge is in favor of the ruling or not. I'm not sure about Spain, but in the UK that's different, in the Supreme Court in the US it's different, but you can just play with this type of things, right? We also did this with the European Court of Human Rights. So that's our development, or the next step of our prediction of court decisions at the European Court of Human Rights. If you go to the next slide. So we don't look at the case, but we look at submission by the party, facts of the pending case, of a judge of a lower court. So we know, for example, we have this Court of Appeal, and then it goes to the Supreme Court, so we can use that text to predict the outcome of the Court of Appeal, or of the Supreme Court. How did we do that? If we go to the next slide. So that's first we need to, first I'm going to show you, before I will give you my example. So remember, this is the big hype. Everybody is predicting court decisions. So if we use this scheme, or if we use this overview and put them in the right category, if you go to the next slide, we just see that a lot of people are claiming to predict, but what they're actually doing is identifying the outcome of the judgment. They're actually doing a good job, right? So, but they're doing it in a much more complicated way than they should be. Probably a keyword search or Ctrl+F search could have done better than they did. They use all kind of very difficult machine learning techniques, but maybe a keyword search on violation, that will be enough. Or just looking at the metadata on Hudol. So that's just the download, and you have the right thing. So so that's probably, they don't have a clue what they're doing in respect with data. But you see that many of them are computer scientists working with non-lawyers, so they don't know what they're actually looking at. Just getting as much papers as possible with as much citations as possible. Some of them are even saying, use this in practice, right? So use this to prioritize cases, or even as a Chinese case, to prioritize death penalty cases. Very dangerous, because basically they're only identifying what the court has said in this judgment. So they're over-promising. Classification, they're also claiming to prediction, as we did, right? The Medeva 2021, that's us. We also say predicting, but actually we're not predicting. And then there are two papers that are doing forecasting, and there are two in the right corner. These are American papers, and they're using this data set from the Supreme Court with political associations, right? So they're not using textual features, so they just say, if Kavanaugh is on the bench, then probably they will vote against this or in favor. Vols et al., that's a German, it's a very early one, it's a special one, it's about German tax law. I'm not a specialist in German tax law, but they actually did this. And we did this. So Medvedeva et al., I'm again the et al., the 2020B. So what's this paper? But the thing you should remember is, if people are claiming I'm predicting court decisions, just ask what they're doing. And be critical as a lawyer, because probably you said, we cannot use this, so this is not useful for us. It's identifying case okay, and judgments, but we already have this data. So why build this data? But forecasting, that's it. It's possible. And then we go to the next slide. It's this paper. It was published end of 2020, and it's the Jury Says project. There's also a website associated to it. I will show you in a minute, and you can just check for yourself how it works. What we actually wanted to do, if you go to the next slide, and the paper is just online, so you can just follow it, and, or you can just find it. How it works. If you go to the European Court of Human Rights, I didn't know this. So we found out during the time we were writing this paper, or when we tried to find what information is available before the European Court is actually going to rule in this case. First you apply, you're a Spanish person, you want to complain about your Article 8 right being violated, you apply, then they check admissibility. Did you go to all the Spanish courts? Right? You need to be admissible. Very basic administrative law and constitutional law stuff, right? So if you did, then the clerk, so the office of the European Court, will send out a communicated case. What's that? They just make a summary of the complaint. It looks like this. So it says, in this case, it's Boix AE against Greece. And they said, we received this complaint about Greece. They sent it to Greece and they make it publish, and they said, Miss or Mrs. Boix said that they were complaining about, I don't know, in this case, it's compensation and hearing. Yeah, they took land of her and she said that was illegal, right? It's just a summary of the case. It's highly biased because it's only the view of Miss Boix or Mr. Boix. But it's published years in advance from the actual judgment. So we know this, that this case is brought before the court, and then Greece can respond, and then the court will take a step, and then it will check the admissibility on merits, and then it will be a judgment. But this is published in 2020, probably the judgment will be there in 2023. So this is all posted online, so cases get this communicated case. It's just a document. For lawyers, we usually don't look at these documents, right? So maybe to have a check, so what interesting cases will come, but I never looked at the document. I didn't know that it existed. But now it's interesting because we have thousands of these documents, and we can use this data to predict the outcome of the court judgment in the end. So if you go to the next slide, this is the Jury Says website. If you go to jurysays.com, you can just check it, and you can check. It's updated all the time, and it also shows how good it is. So what we found here, this is an Article 8 case. I think it's about evictions even. And here you see that jury predicted, let's see whether it's there. Yeah, so the result is a violation case, and it shows that the red words or sentences, so it doesn't look only at words but at sentences, are a predictor for non-violation, and the green ones are predictor for violation. So it gives us some more information about what are good predictors. It's not just looking at dog walks or walks in or Spain Beautiful, it looks at more sentences. Still, it doesn't give me a lot of information because here you see that the word or the sentence, the applicant is a Swedish national, that's a good prediction for non-violation. And but still it is, right? So it's more information. And maybe it shares that Sweden is a non-violator, right? So it might be a good, maybe this is actually this or some information, right? And in this case, Yuri was right. So the result was violation. If you go to the next slide. So you can just click on all the website, and in this case, but I'm not sure about last month, but it was right in 76% of the cases, which is not as good as the 80% of the cases, but still this data is more limited because it's only like this half-page summary, but still we're able to predict in it. So just go to the website and just click on yourself for yourself. Sometimes it struggles to update, so sometimes there's an error, but I don't know about. I don't know now if it's still operating, but it will be operating in a few days if it's not working again. Okay, so this is actually forecasting. So that's what I wanted to talk about you today. Using these data science techniques, I think within your project there are like multiple options to use this. There are some dangers, as I said. So there's this status quo bias. There are all kind of biases, and I think next speaker will talk about that as well. Because machine learning systems look for the biases within the data. They just check if they find that gender is an issue, it will exploit that data. It will exploit that bias. You need to understand if you're going to use it, then it will exploit the biases. So the status quo bias, but also racial biases, the discrimination, and so on. Sometimes we can use this to identify cases, to find the biases. We can even forecast it, but it's not the same as building a robot judge. So I think this is more like an intellectual experience and building richer data sets, finding the biases, then using this in a practical way to replace the judge or not. Right? So we can use it in housing law, but we can use it in different systems as well. It would be great to explore how we can use this in the Spanish context. I think there are multiple options to do that, or opportunities to do that, but I'm not a key expert on Spanish case law. So you are, but we can bring it into your team, people that can work with them. If you want to know more about the project, follow us on Twitter. This is all a commercial thing, commercial break, right? So, but feel free to ask me anything you want today. But for now, thank you so much for your time.
Thanks.
Thanks.
Buenos días a todos. Muchas gracias por la invitación a Armela, que un nombre, por cierto, que me gusta mucho. Porque en el país valenciano Armela significa amendua. Me parece muy bonito. I'm going to talk about vulnerability and black box. In particular, I'm going to try to explain which are the different alternatives to full transparency of the source code, which we have now in our current legal framework or in different proposals that we are debating. Because at least for the moment, it's clear that full publication of source code is out of question in most of the cases. Why is that a problem? Well, that's the quick outline of what I intend to explain to you. I'm going to try to be as quick as possible, so I'm not going into the details because they are not necessary to understand the problem, but you will have the references that you want to analyze in depth some of the questions that I'm going to mention. So I'm going to try to explain the problem, why this is a problem. After that, I'm going to try to make a quick review of the current legal framework that we have in Europe, Spain, and also some soft law guidance, because we have a lot of soft law guidance, maybe too much soft law guidance instead of actual obligations and actual hard law that public administrations, public powers have to follow. And then I will try to explain the different alternative means to transparency, to achieve transparency, other than to publish full source code. We have different alternatives. There are some people that say, well, let's ban everything. Also, we have reverse engineering. We have some ideas that try to improve our current legal framework. Also, we have some proposals about private audit systems and a proposal about specialized administrative bodies. That's more or less the different alternatives that we have. And I will try to assess, I think, how these alternatives work and which are the cons and pros of each alternative. So, the problem. Which is the problem that we have here? The problem, I am going to use 3-4 landmark cases to illustrate which the problem is. The problem is that if we are going to use artificial intelligence and we are to use algorithms in order to make administrative decisions or in order to make predictions about the conditions, the facts that are going to be the base of an administrative decision, then it's important that we know how these artificial intelligence work. Why? Because we have a lot of risks of abuses, discrimination biases, and the problem is that if we use artificial intelligence and algorithms without knowing exactly what's happening inside the algorithm, how the algorithm is working, we can create more problems than the problems that we solve. And it's clear, and a lot of people saying that to use algorithms is or has to be a good thing because we know more about how the algorithm works than how a human mind, the mind of a judge or the mind of an officer and an official in a public administration works. So the black box of the algorithm, other people say, is not so problematic compared with the black box of a human brain, and that's true. But it's true only if we know how the algorithm works. So we have already some cases which have been debated. One of them is from the Netherlands. You know that in the Netherlands 2 years ago, a court in The Hague said that, well, a big project, the Siri project that was about social health and a way to achieve a best control monitoring and also more information and a better analyze of this information in order to allocate social health in a better way. Well, it was struck down by this court because of this preoccupation about biases. Because preoccupation about biases, but the central idea of the decision was not the biases, because we do not have, for the moment, a legal framework that allows courts to say you cannot do that because of this problem. The court evaded this issue and decided that this system cannot be used because of privacy concerns, because the way to make predictions about social vulnerability and how to allocate funds or where you have problems of fraud, etc., was to give a lot of data about the personal life of the people, and they considered that that was a violation of the Human Rights Convention, the European Human Rights Convention, because there was not a proportion between how many data they feed the algorithm and the output, and not enough control of that. So, but it's interesting because we see here at these two things. We see that there's a worry about this problem, because we all know that this problem exists, and that the worry appears when you have a public administration developing a very sophisticated machine, or at least a more sophisticated algorithm than the algorithms that we currently use, for instance, in Spain. And it's normal. When you have the tool, then you see the problems, and then you have the necessity of a better legal framework. Because if not, the problem is that you are going to have a lot of courts saying, I do not allow you to use the algorithm. That's the situation in Europe. In the United States, as you know, the situation is quite different, but also interesting. The Loomis case is a very interesting and well-known case in which we have, that's a criminal case. Loomis was a convicted felon, and the judge, while deciding the sentence, was helped by a system, Compass, which is a commercial system used by a lot of different judiciary branches in the States. I think the data nowadays is that 48 states out of 50 in the United States give to their judges an algorithmic tool like Compass or other commercial, because they are commercial products, in order to help them to understand or to have an assessment of how dangerous is this possible individual, and which are the probabilities of to commit another crime, etc. And they use prediction made by algorithms. The interesting thing is that they use this prediction, and we can see that little by little, step by step, the judges, when sentencing, and the predictions of the machine, of the commercial tool that they use, are highly correlated. So that means that, in fact, they are using that and they are relying on that. But the citizens have no right to know how this commercial tool works. So that's clearly a problem, because you don't have a complete right of defense if you don't know how this evaluation, how this assessment is made, because you cannot contest it. So Loomis protested and went before the Supreme Court of Wisconsin, and the Supreme Court of Wisconsin said, well, that's not an issue, because two things. The first one, it's an excuse. They circumvalated the situation, saying, well, in reality, the software is not deciding anything. The decision is the decision from the judge, so there's nothing to see here and nothing to analyze here. Which is maybe a possibility, and we will see that again, for instance, in Spain. In other cases, you can say, well, that's only a help. The important decision is the judge's decision, and you can contest that decision, so no problem at all. But that's maybe a way to solve the problem in the short term. But in the long term, it's going to be impossible, because in the long term, it's going to be clear that we're going to use that more and more and more and more. And the more accurate and the more powerful the tool is, the more direct connection between the tool prediction and the final decision we are going to see. So it's not possible to say, or maybe today it's still possible, but in the future it's not going to be possible to say. That's not an important issue. But well, the Wisconsin Supreme Court said that, but also said, and that's something that we're going to see again, also in Spain, that well, that's a commercial product. That's we have a software company who has built the product. There's a lot of investment there, a lot of intellectual property there. So we cannot give you the source code, because that's protected. Because that would be a violation against their IP intellectual property. So it's more important intellectual property than your right as a citizen. And it's quite incredible for me, but this argument worked, and the Wisconsin Supreme Court considered that the final element that decided the case. The Supreme Court of the United States decided not to review this case. They considered it was not important. So the final decision was like this, and that's more or less the situation in this case. So, well, to say that we are only using the tool as a help, and to say that the tool is not ours, but we are only using it because the intellectual property is from a company, is working as a way to deter complete transparency. It's quite incredible, but we can see that also in Spain. And there's a very well-known case in Spain related with social rights, related with vulnerability of some citizens in our country, which is the Bosco case from December 2021, regarding the right of receiving some rabates on the electricity cost if you are in a vulnerability situation. So we have a regulation, which is a town regulation made by the Spanish government, and the regulation says that every electricity supplier has the obligation to run a software, which is not made because it's a private company who has made the software, and then we will see again the IP problem that is delivered by the Spanish government to these private companies, and the private companies, they have to use the software in order to decide whether or not this citizen has a right to the rebate, to the reduction in the electricity bill. The interesting thing is that we have a regulation saying in which cases a citizen has a right or not. but the decision is not going to be made after the regulation, typical regulation, but after the decision of the software which is running which every company has to run in order to decide. So, an NGO, a Spanish NGO, Kivio, analyzed the situation and discovered quite amazingly that we have some cases, and obviously it's not the majority of the cases, but an important quantity of cases in which people that they consider comply with the requirements stated in the regulation were considered as non-eligible by the software and the application. So they say, what's happening here? We want to see the source code of the algorithm, of the software, in order to discover what's happening and in order to help to fix it. Because clearly we have an algorithm which is making the decisions, theoretically following the legal framework established in a public regulation, but in practice, it doesn't. Well, the Spanish government said, no, I'm not going to give you the source code, because I don't want to, because it has been developed by a private company and I don't have the right to give it to you because IP protection, and also because of some claimed security risks. This NGO went to the Transparency Council of Spain saying, well, the Spanish government doesn't want to give us the software, but we consider that it's a clear transparency issue because, as you know, the Spanish Transparency Act says that every administrative information that the public administration has to be public with only a few exceptions. But the Transparency Council said no, because of the intellectual property, which is one of the exceptions in the transparency. So this NGO went to the courts, and we have this decision of December 2021, which is the first decision, because the NGO has announced that they are going to appeal. And according to my view, from my point of view, the decision is quite amazing because they gave reason to the Spanish government and the Spanish Transparency Council, and they said that IP protection is a ground to be considered in order not to give the source code in a situation like this, and also that potential security risks associated with the fact that if you give all the source code, it's theoretically possible to run attacks against the system, a system dedicated only to assess whether a citizen has a right or not to receive this reduction in the electricity bill. So this security concern was also considered as a justification for the courts. So we have a problem. I think that it's clear that we have a problem. There are other examples. There are also other examples in Europe, for instance, in some cases, always very simple cases in which the algorithm was like a mathematical formula assessing different situations that were more or less objective. In those cases, we have a lot of cases in which the source code has been offered. But the thing is that we have something to care about here, in my opinion, because it's important to know. It's important to know what's happening in.
Algorithm says no.
Yes. It's like law. And why I consider it important? Because we have other examples and very important examples that are closely related to people in vulnerability situations. For instance, women at risk of gender violence. As you know, we have an algorithm in Spain which is BION, used by the police in Spain, which is used in order to assess the risk of a woman who has denounced a possible situation of gender violence. This algorithm assesses the actual risk of facing an actual aggression. And then the police decides how many efforts to protect this possible victim and how many measures of protection has to be implemented in order to protect the victim. This software is really interesting because, of course, we do not have access to the source code, but also because the software has been used for almost 15 years now, because Spain was kind of a pioneer in gender violence issues, as you know, because the Spanish Act on violence issues 2007 it was quite new. There are many countries in Europe that went after Spain, and that created a situation in which we allocated a lot of funds in order to build tools like this. So we have a head start. We are early starters in this. So we in fact, a lot of European countries rely on data of Biogen and are using Biogen as a model, not only in Europe but also in other countries. So our police, our government is really proud of Biogen and how Biogen works. Problem: Biogen can create or can be related to a lot of possible vulnerability concerns relating the victims or the alleged aggressors. For instance, it has been already mentioned by Michel, is a good predictor the condition of being migrant, if you are the victim, the possible victim, or the condition of migrant of the possible aggressor. Is a good predictor race, is a good predictor income, is a good predictor the neighborhood in which you live. And you have the problem with algorithms, Michel has explained that really well, that you feed the algorithm with data. If those data are good predictors, the algorithm, especially if the algorithm has been designed with machine learning features, the algorithm is going to analyze those data. If those data create a good prediction, the algorithm is going to even reinforce the importance of those predictors, and that could create a risk of assigning too much importance to conditions like race, gender, etc. So that's why it's really important to know how the algorithm works and which is the way to ponder every feature, every element, or every data in order to control whether it's producing those biases or not. How Biogen works? Biogen is not a machine learning product, which is good because it's less problematic. It's like a simple algorithm in which you give each feature or each element a percentage of the total, and then you have a score, and this score is the score the police use in order to analyze the situation. Which means that, at least theoretically, it should be not so difficult and not so problematic to give this information, to share this information to the public in order to allow an audit from the outset. Because why not? What's the problem? And here we have, but the police and the Spanish government, they consider the algorithm works well. They say we work with experts, which is true. They say we conduct our internal analysis, which is also true. They have published a lot of papers in which they explain how the algorithm works and which is the success rate in each case, which is true. But the problem is that they have published this assessment, different papers, but always made by people who is inside the system, who has been part of the design team of the system. So we have to rely on them, and we do not have all the data. Is that problematic? I consider it is. and also I consider it is unnecessary. But it's not as problematic as it were if Biogen used machine learning, and also it's not as problematic as it were if Biogen not only deals with the protection of possible victims, which is the case now, but also imagine that Biogen is also used because it works fine, and this is what they say, and I think it's true. It's not only used for that, but also in order to restrict or control the possible aggressor, which is a different thing. Problem: the system works so fine, and they are so proud about the system that right now they have decided that they are going to implement as it's a project. They are going to see how it works. So it's, for the moment, it's a beta, but they are going to introduce some machine learning features. That means we are increasing the risk. And also, they are considering to use the system not only for the protection of victims, but also in order to decide which kind of measures should be taken before the trial in order to control possible aggressors. Therefore, maybe the situation of not giving the code is no more a possibility, and the Spanish government, I think they know that, and 15 years after the launch of the Biogen software, they have decided to accept some external revision, and that's something that the government published 2 weeks ago. They said, well, we are going to accept that some team, which is not our team, is going to review the system. I know the situation well because it's our team. And it has been really costly to convince them. And the idea was that you should understand that if you have a wonderful tool and you consider that this tool works finally, then you should accept external revision. Because if not, you have a problem of confidence from the population, and if not, you cannot implement these new things that you want to implement, machine learning or using the algorithm for other things that are more problematic. Because you can create a lot of risk, and you need some external output. So we are going to try to do that. It's something that we are going to do with Amnesty International. But I have to say to you that when we speak with the police, because we went to them and to try to explain to them what we wanted to do, why we considered that was important, etc. We understand that for them they have reserves, they have reservations because it's like their baby, and they love so much their baby that they do not want anyone to harm them. Well, but that's more or less the situation. So why I wanted to explain to you this example, because I think it's good news. Public administrations are understanding that it's important to give more access, but it's complicated. And we are going little by little. And it's complicated because the current legal framework allows them not to share this information. The only thing that we have from the European law perspective is Article 22 of the GDPR and Article 15 of the GDPR. I think you already know what they say. Well, we have also the recital 71 of the GDPR, but it's the recital, it's not the article. And the only the part of the GDPR where you find a more intense obligation about you have to explain how this algorithm works is not in Article 22 or in Article 15, it's in the recital, which is kind of soft law. Well, but the only thing that we have is this idea, Article 22, that a decision based solely on automatic processing, in principle, is not possible if a citizen says, no, I don't want to be treated only by a machine. But Article 22 of the GDPR is thinking mainly in private companies, not in public administrations. And that's why Article 22(2) says that we can exclude this rule when we have a law allowing that. For instance, in Spain, we have laws allowing public administrations to run decisions based solely on automatic process. So it's not working as a way to harnessing public administration. It simply doesn't work. And Article 15 is the right of access to an explanation about how it works if you are being subjected to an automatic decision. But as you can read, in fact, the obligation is really light. It's a light obligation. It's only in recital 71 when you have a more hard obligation, saying you have to explain how this algorithm works and you have to try to explain to the people which is the logic under the system. So our legal framework, our European legal framework is not enough, and that's better. Maybe it's enough, but what you have is what I have solved. And this for them. Current Spanish legal framework. The current Spanish legal framework is only one article in the Spanish 2015 Act about how public administrators have to act, and is more or less the same idea as the idea in the GDPR, but the same idea taking into account that we are a public administration because we are regulating how public administrations work. Therefore, we accept solely automatic decisions, and the only requirements is that this decision has to be more or less explained. We have to have an administrative body responsible of this automatic decision, and this administrative body should be held responsible if something happens, and in case you can go against the decision, this administrative body has to offer an explanation. That's only an explanation. So that's clearly not enough. But that's what we have, and we have also some soft law guidelines. Soft law guidelines which are more accurate and more sharper, but always using this idea of explainability. What we see in the different soft law guidelines that we have is that the focus is always on explainability. You have this 2021 UNESCO recommendation, you can see recitals 37 to 41, and you will see that the focus is on explainability. As long as you offer complete explainability, that's enough. You don't need to offer the source code. GDPR, recital 71, and also in Spain, that's a wonderful thing. I don't know if you know that. We have a 2021 Digital Rights Charter with an Article 25 about rights relating to administrative intelligence and an Article 18.6 about rights related to artificial intelligence when used by public administration. And the more fascinating thing of this Digital Rights Charter of 2021 is that they have only introduced what we already have in the legal framework, which is currently in force. So I don't know why to create a new digital rights charters in order to innovate. 6 years later of the 2015 Act, only to repeat what we already have in the GDPR or Act. So it's true that maybe with more stress on explainability, but it's only a question of stress. So no real changes here. So what we see is that we have a current legal framework which is not prepared for the things that we are going to see in the future, and which is based on this idea of explainability. When a public administration is running an algorithm system that is designed to make decisions that may affect citizens, the only obligation is a proper explanation. Is that enough? Well, In my opinion, that's not enough, and we need in most of the cases the complete source code. But I understand in some cases it would be difficult. Cases in which it's possible to game the system. For instance, when you are using the algorithm in order to control or detect fraud, or maybe the nature of the algorithm in the sense that algorithms are adapted day by day because you are making them improve as soon as you can. Maybe it's complicated to give everything as soon as the algorithm changes. But well, we can fix that. We can try to establish a new regulation. But for the moment, that's out of the question. That's out of the question. And we have this idea of explainability, and that's enough. And explainability in a very light way. Well, a lot of people is saying that's not enough, so a lot of people is proposing different alternatives to this situation, which is considered to be not admissible. Which are the different alternatives that we are discussing? And I'm going to try to explain them quickly because we have to. Well, the first one is to say, well, if for the moment we are going to ban the use of alternative artificial intelligence in some cases because we consider there are so many risks, and those risks do not compensate the gains that we can have. That's the approach of Germany when we are dealing with discretionary decisions. So they allow the use of artificial intelligence in order to help decisions which are heavily formalized. For instance, I consider that the decision regarding the electricity bill in Spain should be one of the heavily formalized and not a discretionary decision. But it seems that, at least we see how the algorithm works, that there's kind of discretion. But the Germans have said, well, for the moment, discretionary decision, no, but that's an alternative. But that's not only the German position. If you see the United Nations document about the right to privacy in the digital age, and also the proposal that the European Union is preparing about Artificial Intelligence Act, you will see that in some cases there are possible uses of artificial intelligence made by public powers that are considered to be too risky, and therefore they consider that they have to be a complete ban. Systems regarding identification of people or deep fake or that kind of things are going to be probably prohibited for public administrations in the near future. Well, pros of this alternative is a very simple solution and is easy to implement. Because when you establish a provision like this, maybe if the provision is aimed to the private sector, it's complicated to implement it. But when the provision is directed to public administration, it's easy to implement. So it's simple and easy to implement. Cons, disadvantages. I think it's obvious it's difficult to sustain in the long term, because if we have algorithms that works properly and that can create an advantage, there's going to be huge pressure to use them as long as they promise and they offer, they deliver more efficiency. So at least in the German version, I think that's difficult to sustain. In fact, it's when we deal with discretionary decisions, when artificial intelligence and machine learning intelligence is more interesting. Because if we are dealing with a regulated set of features which has already been decided by the regulator, and you know exactly which is the proportional weight of each parameter, well, artificial intelligence there doesn't offer a lot. But when we deal with discretionary decisions and we need to ponder a lot of things that we don't know exactly how to balance, is when a system of machine learning can produce more efficiency. And we see that in other fields. For instance, in medicine, when artificial intelligence in medicine is more interesting, when you have to deal not with a very, very simple diagnosed, but when you have to decide whether this or this and this and this means that you have a risk of cancer. And beyond the point, artificial intelligence makes those decisions better than a human. The pressure for using administrative intelligence is huge, so we are not going not to do it. But the exclusions of the European Union Artificial Intelligence Act, well, if you see Article 5 of this Artificial Intelligence Act proposal of the European Union, well, maybe in this case is sustainable, because those are systems that the balance between rights, freedoms, no, we don't want a China system with a social score or facial recognition of every citizen on the street, everywhere, etc. And those are the kind of uses that are prohibited according to this proposal. Maybe in this case it's possible to maintain that in the future. That will create the necessity of a public debate about where those limits are. And that will be problematic in some cases. But that's alternative one. But alternative one is not really interesting because we are not going to use it, or at least we are not going to use it in those fields. Other alternative. Alternative two is to use reverse engineering or other technical and fixes. There are at least, two interesting ways of analyzing this. The first is the traditional reverse engineering that works. For instance, in the Loomis case, they conducted that, and that's why they discovered that in some cases the software using Wisconsin, this compass software, has had, because they said they have already fixed it, some racial bias. Or for instance, that's what Kibio has made in order to try to analyze what's happening with the electricity bill software here in Spain. So you can use the outcome that you know and then try to imagine and use mathematics and different reverse engineering systems in order to try to imagine how the system is working. The problem of this is that it's complicated, it's limited, and you have to do that using a lot of resources and a lot of funding because the government doesn't want to give you the algorithm. And there's another proposal, which is a proposal made by a scholar from Oxford University, Sandra Bachter, that says that, well, if the governments, if public administration don't offer complete source code, at least they should allow citizens and NGOs to do counterfactual searches. That means to have the software in order to have the possibility to say, well, what would happen using your software? You have to put your software at my disposal in order to allow me to say, if I change this, what happened? If I change this, what happened? And that's a very interesting approach because it's a way to facilitate the reverse engineering systems. Because if you have the possibility to know counterfactual explanations and how the software reacts to different changes or minor changes, it's easier to understand how the software works. So that's a possibility. Pros. It's already in place. We have some experience doing that. It's a way to do it preserving intellectual property. Broad availability, because as long as you have people interested in doing that, you can do it. And it's also a positive thing, an advantage, that you can do that with only minor legal fixes. You don't need to change our legal framework to do that. You can do that tomorrow without any change in our legal system. Disadvantages. Well, it's better than what we have now. We have the possibility of reverse engineering, but if we would have the counterfactual explanations proposed by Sandra Bachter, that would be better than what we have now. So that would be a good thing, but it's not a complete understandability of the system, and also that only works when you have a civil society with a lot of interest in that and a lot of experts which are forced to use a lot of time and resources to do this analysis. Third possibility is the possibility that we have, that we see in this soft law, which is to increase the current framework based on explainability, trying to force public administrations to offer not the level of explainability that we have now, but far more explainability than the level that we have now. That's the thing that UNESCO, European Union, and other examples also in Spain are giving. And there are some public administrations which with interesting projects of saying, well, we have a legal framework. This legal framework doesn't force me to offer a complete explanation, but I want to do that. And I think it's better to do that. And they are offering more than the legal framework forced them to do. And that's a good thing. And there are some examples, for instance, in Amsterdam, and also in Valencia, last Saturday, the new Transparency Act established the obligation of doing exactly the same thing that Amsterdam is doing in every Valencian public administration, which I think is a good thing. What Amsterdam is doing is, the city of Amsterdam, is to giving all the information, not all the information because they do not give the source code, almost all the information of the different algorithm systems they use. So they have a web page, a register of algorithm systems, and you have the different algorithm systems they use at local level, and you can click, and then you get a complete information, a detailed information about how the algorithm works, whether this algorithm has machine learning or not, whether this algorithm uses natural language processing or not, whether this algorithm, and they explain that to you. An interesting thing is that a year ago, more or less, they have more information than the information that they have now, because I reviewed information this week in order to analyze what they are offering now, and I discovered that they have eliminated the source code in some of the systems, because 1 year ago in some of them you didn't have the source code, but in others they offer, and now they have eliminated this possibility, which means that they are still balancing which is better or not, and the idea of giving the source code, it's not the solution right now. But well, that's far more than we have in almost every public administration, and it's a good step towards the idea that, well, if we are going to base all the protection of citizens in this idea of explainability, at least we should have the more explainability as possible. And that's why the European Union proposal, you know, I guess you have read it, this proposal from last year of the European Union, they want to enact a legislative act from a European level, and the idea of explainability is absolutely crucial in this proposal. They will force public administrations to offer far more explanations than the explanations that for the moment we have. For instance, Article 13 of the proposal. You can go there and you can see that there's a list of different items that you have to offer, different elements of pieces of information that you have to offer, which is far more than the situation. Well, and as I said to you, in Spain, the only case I know where there's a legal obligation of doing that by default is Valencia from last Saturday. And that's why, well, some people in Valencia, we try to convince the government, and the three parties that compose right now the majority of the government were more or less convinced, and they amended their proposal, and they have introduced in Article 16 this idea that every public administration in Valencia, which means not only the regional government but also local authorities, they have to do what Amsterdam is doing. I am a bit excited about about the final result, because it's complicated, it's a change of culture, but I am happy about the fact that we have at least that in the legislative act. Pros is already in place, it's only to make what we are already making, or theoretically we have the obligation to do, but better. It preserves IP and only minor legal changes in the framework needed. Disadvantages. Limit well, the complete understandability of the intelligent artificial is not guaranteed, so it doesn't really solve the problem. And another problem, in my opinion, is that this alternative to give the source code is far more dependent on public authorities than I consider is because it depends almost everything in how much information they want to do. You can always go to the courts and ask for more, but by default you depend on public authorities. And the two last systems, which are systems that we, for the moment, do not have in place, are private audit systems, which is the idea, or well, we cannot give source code to everyone because that's dangerous, because IP protection, but we can select some private companies or some private NGOs or some private institutions which are reliable enough, and then we can give to them this source code, and we can make them the official external auditors of these public administration's algorithms. That's a typical self-regulation approach. That's very popular in the among American scholars. Well, we have some pros, some advantages. There are some experiences. Well, of course, we can regulate it in order to preserve intellectual property, which is the main concern in some cases. But the problem is that intellectual property, in order to preserve intellectual property, you have to have a very limited number of external auditors, because if not, the danger of a leak increases. And at least this control is made from the outside, not from the public administration in charge of the algorithm, which is good. And also, it implies some civil society activities, which is also good. But there are also disadvantages. Limited access, especially if intellectual property protection is promoted, because in that case you are going to allow only a very limited number of organisms to do that. It's complicated how we how we assess and select these private partners. And there's a question of trust, because, for instance, if you know a system which is more or less similar, which is the system that the European Parliament has tried to create in order to assess fake news, selecting some private NGOs or associations as the official verificators for fake news on behalf of the European Parliament, in the end the problem is that there's a complete suspicion that if you have been selected by the European Parliament in order to assess fake news, it's because you are not reliable, because you are not going to be problematic for the European institutions. And that's more or less the problem that a system like this can create. And finally, the last proposal, which is a typical German proposal, is that the German scholars are saying, and maybe because this typical German proposal is what the European Union in this it's in the proposal of the European Union about how to regulate artificial intelligence. What we see is this proposal, which is to create a specialized administrative body, and we see that in Article 30 of this proposal. The idea is that if this proposal in the end is the European Intelligence Act, the idea is that each member state should have an agency in charge of the control of the algorithms used by some private actors, but especially or also by public administration. It's like our data protection authority, but regarding algorithms. That's typically German, and that's why I assume that the future that we are going to see is this and more explainability requirements. Is that enough? Is that enough? Well, in this case, we have some advantages. We have a broad experience with independent administrative agencies, so we know how this works. And at least this agency is going to have complete access to the source code. Disadvantages. The control is going to be made by a public administration, even if it's an independent public administration, not by social society, not by the citizens. So it's control concentrated in public powers. And, well, it's also complicated in terms of funding, because we will need another agency, more civil servants, more workers, and more funding. So if you liberate source code, things are made by the citizens, so it's cheaper. But in my opinion, that we are going to view, to see in the future, that we are going to have the combination of more explainability of relations with these agencies. In fact, the combination of these two solutions is what we have in the European proposal. Only 5 ideas to end. Still, we can detect significant reserves to accept complete transparency. I think that's clear. Even in the proposals, we do not see complete transparency, so that's clear. Second idea, the money is an important issue here too. It's an important issue because if we have to build an agency, that will cost money, and therefore, what is going to be a possibility is to use an already existing agency, for instance, data protection agency, and say, well, you can do that too, which is not maybe the best solution. But also, that is important because the typical problem about IP and about security risks can be demoted, but we will need more money dedicated to private, public administration algorithms if we want to have algorithms that are not private property, but that are owned by private administration. So money is an issue. Well, it's not the same, I think, and we have to reflect on that, whether the control is made by public powers or by civil society or private agents. I think that that's something we have to reflect. And the other thing, and that's my personal opinion, is that every alternative proposal to complete source code transparency has a lot of weaknesses. So maybe the best solution is to say, well, of course, complete source code transparency has also problems, but given the fact that the other solutions have a lot of problems, maybe it's worth to try to solve the problems with complete source code transparency, even with some limits, even with some exceptions, and pass to that step, because that will be, and that's the final idea, that will be the final solution. I think I cannot imagine a world in which we have very powerful algorithms run by public administrations making decisions, and I cannot imagine a future, or I hope we will not see that kind of future, in which if they are doing a lot of things, and they are doing very important things, we do not have access to the source code. So the more artificial intelligence we have in the future, the more controls will be demanded, and in the end I think that we will see step by step more cases of complete access. So that was more or less what I wanted to explain and to share with you. Many thanks for the attention, and we can get some questions now and debate.
Okay. Pablo is a constitutional law doctor of the University of Vigo.
Well, I'm a rookie at this field, so I apologize in advance for the evidence I can disregard when I pose my questions. Yeah, it was great, very interesting, both conferences. I have a lot of questions, but I'll try to sum up everything in 3 questions, right? Yeah, so first question, and that's more for Professor Voix. So the source code, when it is a source code of a program that belongs to the state, cannot consider the source code state help information in the sense of Article 10 of the European Convention of Human Rights? Just a question, right? Because, so I understand the concern of the IP protection, but I also see strong public reasons to undermine this IP protection. So, and I was just wondering if we could consider that state help information. We know that the right to access to information is rather weak, right? Because we have to meet several how's the word, criteria. So we have to look at the purpose of the information request, the nature of the information sought, the role of the applicant, the availability, and all these criteria needs to be met. But anyway, so I don't want to go to the details now. Just the broad question: can we consider that state help information in the sense of this article? That's the first question, right? The second question is a question that arose when you talk of the first German solution, the ban of these tools. Yeah, so maybe I'm too traditional and too influenced by the German scholarship, but I don't see that so mistaken. And I tell you why. You use an example that is convincing but not completely, the medical example. Exactly, when you have to diagnose a cancer, you have something that is objective and you have to find it. And to find that, you need, so that's something that is there and you have to find out. When you have discretion, what we recognize is that we don't know the solution, or that there could be several solutions. There is not just one solution. And from this point of view, there could be good reasons to use, not to use artificial intelligence, but traditional systems, or to combine them, right? But so, of course, artificial intelligence is sometimes faster, I guess. I'm not very keen on this topic, right? But I guess it's easier to make decisions, it's faster, but I think we should consider this problem of the discretion, right? It is not irrelevant. And I forgot the third question, sorry. But yeah, so I think it will come back. So yeah, if you want to answer that, it's fine.
We have some other questions, maybe two more questions, and then you answer everything. Mireia Artigot, she's in the Universitat Pompeu Fabra, Barcelona, and Alba also has a question. So Mireia, go ahead. No, you can't listen. Just a minute. Ahora, más. Espera, a ver si subimos el volumen. Okay.
Can you hear me?
Yes.
Yeah. Thank you very much. Thank you very much for the fantastic presentations, and I heavily regret not being there with you all today. And I have a question for both speakers. The first one regarding the eviction project. I have two questions. One of them refers to the interpretation of the results. Like when you were talking about the data set, but there's an issue of the data set regarding the first sampling question that comes from the amount of case law that you get from the different member states. So how do you come around that so that you don't interpret that there's variables that are not, let's say, I understand that you do it from the actual cases that you have from the European Court of Human Rights, but I find it problematic that would result in just interpreting the significance or not of whatever, let's say, variables or parameters that you are looking at based on the language. That could represent a subset of the actual vulnerabilities that take place in terms of the right to housing in the actual positive case law in the different member states. So I wonder how you come around that, because it's an absolutely interesting, and I'm very convinced that's the future, one of the future lines that we should take. And the second one is for Andrés, which refers to the issue of this question of explainability. And I wonder whether knowing the actual coding, the algorithm that provides information on the design, whether that's enough or would be of actual any use, because the algorithm, we only know how it works when we know what is the data that is being fed. And if this data is biased, or this data, the data set does not represent or does not weight, as you are saying, like the algorithm in many cases like replicates let's say the status quo, right? So it just learns from the past. And from here, there's these dynamics that projects to the future, but in a very, let's say, it doesn't learn from the complexity of the dynamic reality, right? It's always stuck in the variables given by the data set. So if we only know how the algorithm is designed, we only know potential discriminatory practices at the design level, which would be relatively easy, right? Easy, of course, if we have this information. But there's the second dimension, which is that we can have a neutral algorithm designed in a neutral way, but then depending on the data set that you are feeding, and here we have all these gender, racial, income, education biases, to train the algorithm, you could get discriminatory results just because the data set that you are getting is biased. And I don't think we can get that, not even in a public, the private perhaps, but not even, because that would violate the GDPR. So do you have any thinking on how we could overcome this problem? Thank you to both. Well, and to all of you.
Okay, Alba. Yes, thank you for both presentations. They were brilliant and very interesting. I have one question for each of you, and probably very inspired from my field of knowledge. So for Michel, it's really nice to see a project that speaks my language in terms of emphasizing methodology so much. It's really nice. I do agree with you that the use of predictions is a big word for social sciences. So I wonder whether you're gonna exploit your data in another sense that is not so focused on predicting, which I think is very problematic, and more in what can we learn in terms of improving policy. Where I missed in your presentation, maybe it's part of the prediction project, I don't know, is to learn lessons from that case law that you've been studying in depth, and whether one part of the project relates to that more, let's say, normative perspective that looks to improve policy. So just that was in case you're thinking of doing something like that. And for Andrés, I really like the presentation as well, and I'm really interested in the part of studying the Leo-Pen algorithm, which connects with what we're doing in this project and my expertise. And again, with my political science lens, what I see there is a lot of potential in terms of connecting the use of the algorithm, which has such a long trajectory, let's say, with the evolution of the policy. Because from 2007 till now, with the crisis in the middle, that policy had a lot of changes in terms, especially of resources. And you said that the algorithm has been improved through time. So I wonder whether there is a connection in the evolution of the algorithm and the resources that were invested in the policy, which from the period 2011, 2015 increased seriously at the international level. Then with the national agreement, it went up. So I wonder whether the algorithm as a component of the decision making was affected by the resources, whether your analysis can connect the history of the policy.
I think Andre has a question, and think you can answer to this bunch of questions. We can ask again.
I would like to thank both presentators. I think they were very great presentations. But my question is related particularly to Michel. It's maybe delving on the technical part. I wondered whether there's any possibility to add more layers to the machine learning process in order to get more complex reasonings as predictors. Because you got those two words combinations, but I wonder whether you could exploit more complete reasonings, legal reasonings maybe, in order to, because I think one of the most interesting parts of this kind of classification is getting out those predictors. Because they have actually interesting legal value in order to research. So whether there is any possibility, or if it is efficient, because maybe it's possible, but in terms of cost, it's not efficient, in order to delve into the research.
Okay, go ahead.
Can I pose some questions to Michel too? No, because and then see he can because I have 3 questions. No, but I am going to
I don't think you're going to do your test.
Because there are so many questions to comment. Now, the first one is related with Andrés' questions, but it's simple. Did you find good or interesting predictors? Because I think you explained that perfectly. Your work is interesting because it offers not only the possibility of predictions, but also to understand why judges are going to decide in this way or this way. So it's really interesting to whether you have detected good predictors or interesting predictors, maybe because they are predictors that should not be there. So did you find any of them? And also, second question. What do you think about the French debate that was traveling 2 years ago about the idea that prediction algorithms relating to judicial decisions should be forbidden because they affect the functioning of justice? What do you think about that debate? Because in fact, they published a legislative act saying that they prohibited them, but it's complicated to enforce the act because we all know that private candidates are using them, and also that scholars are doing that kind of work. So, but do you think this idea that is a bad thing to have at least some kind of predictions is true or not? And the last question is related with this other, the other side. So not the prediction made because we are interested in how the system works and how judges are working from a theoretical perspective, but from a practical one. So the algorithms used by private cabinets, by lawyers, that we know they are using them. In some cases they are opposing them, and maybe in some cases they are really accurate. I am thinking on the smaller the field, the better the results you can get. For instance, I think it's quite common today in very specialized lawyers dealing with problems in travel agencies or planes, and so torts related with that kind of. They feed the data, and they have a very clear image about whether the claim is going to be successful or not. So, and they are using that out. Have you or your team or people doing the analysis that you are doing? Do you know if they are also using these algorithms used by private practitioners, and if it's possible to learn something from them? And I think it was really interesting
as well. So
yeah.
I was wondering. So thanks so much for the presentation. But I was wondering, what do you think of neural networks? Because neural networks, they are good algorithms, but they're non-explainable. So you get the source code, and then you have the source code, and you get the outcome, but then you don't know what biases it used. But it's good, so it makes sense, right? So, but if we solve this issue and then we provide this administrative agency or the private regulator with a neural network algorithm, what should we do? Should we ban that or should we use that? So what do you think of that, right? Shall I start by a question from Barcelona, from Mireia? Did I pronounce your name correctly? Great. So I think it's an interesting question. So I will just reformulate your question or how I understood it. If I'm wrong, just let me know, right? So how do you take into account the national characteristics of case law and specific vulnerabilities in that case law? Might be different on a European level than in a Dutch context or in the Spanish context. Is that your question?
Yeah, well, just a little note.
Yeah.
If you only take the positive judgments of the European Court of Human Rights,
Yeah.
you get a subset of the potential violations of the right that you are looking at.
Mm-hmm.
Because, for example, in the case of Spain, we know that the amount of cases that make it to the European Court of Human Rights is extremely scarce, and that doesn't mean that there's no violations.
Yeah, so you're completely right. So within the project, we differentiate between the European international level and national level. So what we're going to do, and we started like a year ago, right? So we've not done everything yet, and it also depends on availability of data. So we basically experimented with the European Court of Human Rights, so whether it's possible or not. And that's, of course, as you said, there's a bias, a selection bias in that, because most people don't go to courts in a national state, and most people don't go to Strasbourg at all, right? So we cannot like learn which people are more addicted than other people, right? So on a European level, we can see what are good predictors for the European Court that for making a decision on that level. But you're completely right. It doesn't tell us anything on which people are addicted in Spain, or what type of vulnerabilities play a role, or what type of arguments they use. So within the project, we take into account the availability of data, and on the national level, especially at lower court level, we focus on the Netherlands, because we know that there is a lot of data on evictions within the Dutch context available. So we're going to focus on using machine learning in these Dutch cases. I'm not sure whether we have time and people available to look at the Spanish case, but what we're going to do in Spain to see how the Supreme Courts in Spain deal with cases on eviction. Still, we're probably not good, but maybe there's a good data set that we still have 3-4 years. Maybe if we find a good data set in Spain, we can experiment with that as well. But now we're planning to use the Dutch data set and then see within that data set whether any features pop up that deal with the right to housing, as I said. So if we find that gender might be a good predictor for non-eviction or eviction, or having children, or legal strategies, right? Referring to the European Court of Human Rights, having a lawyer or not, so we can take into account different things. But we need to build the data set. And the first step is building the data set, and that's what we did with the identification experiment, right? So it's from an intellectual perspective, it's not that interesting, but now we have around like 3,000 to 4,000 cases on evictions in the Netherlands. And now we're going to use that to find, for example, references to the European Convention, references to the Child Rights Convention, gender issues, seeing how long the judge is in office already. Right? So there's another database where we can see, is this a very old judge or a very new judge? And there can be all kind of hypotheses, right? So if you've seen thousands of cases as a judge, maybe you're more lenient or compassionate, or even more strict, right? So we're going to take that into account. Still, to take into account like the specific national context, we need to combine research techniques, and that also answers your questions a lot. Now today I focused a lot on the data science techniques because they're the most sexy techniques within the project. But the majority of the project is just a traditional legal project, which is focusing on doctrinal legal research, human rights legal research, and some normative legal research. So that allows me to move to Ola's question. She said, yes, and now we used, and I explained the machine learning techniques, which learns us a lot from a methodological point of view. So how can we use legal data? What is legal data? I never thought of, when I did my PhD, that the words in the judgment itself are the data. We usually think, if we think about data, then we think about, okay, we have this case and we found 100 cases, and our data set are these 100 cases. Now my data is all the different words in the data, and the gender of the judge is a data point as well. And we combine all type of research techniques. For example, we also do systematic content analysis, where we have a lot of research assistant coding cases, but also how strict is this judge on a scale, right? So very strict or none. We cannot have a machine doing that. Maybe later on we can train to do it. But we also use doctrinal legal research and comparative legal research techniques, where we take into account legal theoretical frameworks, but also non-legal theoretical frameworks. For example, one of the questions, or the main question is, why did the right to housing have an impact or not? And then we can have a look at, from a legal perspective, right, so what's the role of the right to property in a legal system? Does horizontal application of human rights, or do human rights work in a vertical way or a horizontal way? How do legal scholarship and judges and governments look into that? What impact did the international law has on policy making, and also on legislation? I think in Spain we've seen some parties taking into account, of course, the European legislation, but also more theoretical frame from a political science perspective, like what's the amount of backlash and resistance towards international, and debates on sovereignty. Of course, we've seen a lot of resistance towards European Convention on Human Rights from Denmark, from the UK. I'm not sure about Spain, but I'm pretty sure that the whole Aziz judgment from the European Court of, or the Court of Justice from the European Union has been criticized a lot from Spain, probably, because it was an intervention in the middle of the financial crisis from the European Union. There would be political perspectives that can be useful why that worked and why this specific judge in the Aziz case decided to ask the questions to you.
You forgot Pablo's because you didn't take notes on Pablo.
So sorry.
I posed two questions, more focused on the conference held by Andrés. I asked about the possibility to consider the source code as state health information, and the other point was if there are good reasons to distinguish between some cases that can be solved through an algorithm and other cases in which discretion recommends to give a stronger role to a human.
Yeah.
More or less, that's the broad consideration.
Yeah. So thanks so much. I remember the question, and I thought they were posed to my colleague. But I agree with you on the state health information. I think that's a strong, and I will come back to that in response to your questions as well, because that's a strong point in the French debate as well. The second case that can be solved, so we wrote a more ethical piece on using these type of techniques, and I think you're completely right. So where you have non-discretionary cases or cases where not that high stakes are involved. For example, we use the technique to predict rent control issues. So these are very simple. Or in the Netherlands, they're very simple. They just look at the square meters of whether there's a kitchen and whether there's a garden. There's just the big boxes, and then you can decide how much, whether the rent is too high and how much it should be low. I'm not really against using machine learning techniques to do that, if that speeds up the process. Of course, if the system, if the checkboxes change, then we should change the algorithm. But in this case, there are no real high stakes involved. Like it's just around like a few euros. Of course, that's a lot of money for a lot of people. But it's not that people are saying there are no human rights violations involved. Well, not at least that's strong. So I'm not against that. So I think. Where more discretion comes into place, then you should be more careful, right? So, okay. Then André, so can you, basically your question is, can you add more features? right? So now we use bigrams and trigrams, which are very simple, but we had to start, right? So we already do that a bit by the USS, where we have like whole paragraphs and sentences. Still not very convincing. What we're trying to do is mine things like from the cases, like gender, how long courts are in, how long judges are in office, so more like non-legal information, but also things like do parties refer to European law or the international law or not. It's also a binary thing. Which article? We also want to predict whether, for example, a tenant or someone else who's suing the state is using international law or not. Can we predict that type of things? In which cases do people refer to CEDAW, to the Child Rights Convention? We can do things like it, so we don't only need to predict the outcome of cases, but we can also predict what is the topic of a case. Are they using international law or not? So if we have that type of data set, we can also use that to predict the outcome and see what are the predictors, see whether they're good predictors. In the end, what we want to do is a thing called argument mining. So can we mine the arguments from the cases? So that will be difficult because then you need to have like a lot of human coders extracting arguments from case law, and then learn the algorithm to identify the same type of arguments. But then, for example, we can use like, this tenant said that he paid his rent and he has children, and combined with that, that's a good case for Article 8, and therefore he should not be evicted. Like mining that type of information should be possible, but is something it takes some years. And some people are already working on it. It's quite successful, but it's like minor projects, and you need a lot of data, right? So the eviction cases are good, and I think social security cases will be good, labor law will be good, tax law will be good, but like minor cases with like where only a few cases, we cannot do that because you don't have enough data. And even the European, so you need like thousands of cases. So if you just have a few cases, you cannot train your. But it's a good question, and this is just a pilot study, I would say, with bigrams, trigrams, and they're very simple. But there should be more developed, right? So we will develop a little bit more. Then I move to the last three questions. Did you find any interesting predictors? Not really. Because we only use bigrams and trigrams, so if I look at the predictors, I cannot make sense of them. And to be honest, we didn't focus that much on explanation of the predictors yet. So first, it takes a lot of time to build the data set and then do the experiments, and we didn't have a team of lawyers looking at all the predictors, and we're planning to do that, right? So the only thing is interesting is the judges, right? So names of the judges, there seem to be decent predictors. So we put some effort in maybe discrediting the claim that they're biased, because that's the immediate reaction you get from, or response from people. You get, so they're biased because this one is associated with violation all the time, and I think that's unfair because they can be consistent as well, right? So as I already said, so but like for the more legal predictors, we didn't find any interesting predictors yet, but we didn't put that much effort into it because there are now only bigrams and trigrams. So we want to continue with developing more interesting features. You have a question concerning that, but I'm also looking at the chair.
Yeah, of course.
A couple of very good comments. In my case, I think that I'm outlier here, in the sense that I'm in the other part, let's say expert on artificial intelligence. And there are many things related to the problem that we have today. One important thing is distinguish between software, artificial intelligence, and machine learning. Because nowadays there are high expectations about what artificial intelligence can do. Everything is smart, everything is with artificial intelligence, but this is not true. There are many programs that are just software without any intelligence. So we should keep this. And also, inside artificial intelligence, there are expert systems where you have rules that you can try to understand, and then we have machine learning. And even in machine learning, there are many different things. As you say, neural network are special case black box that is different from decision trees or other. So this is something to keep in mind. Also, the data, the amount of data that you have, is important to see if there is a generalization or not in the result, and you can predict. So in that sense, 2 points. One, you are using natural language processing techniques. I know that you are not going to all to detail, but most of the natural language processing techniques, they are optimized for English. And I saw your paper that you say that you were downloaded and created the data set with English cases, not all the Arabic and French. But afterward, you told that you were focusing on the Netherlands, on the Dutch cases. I suppose that there is Dutch language, not English language. So I wonder how you are doing if you are using what you learned from English to go to Dutch and then relying on a translator, what is also with a lot of potential bias and a lot of problems. And also about the contextual information that is around, because when we have a machine learning tool, this is the data set, and the tool learns about this specific data, but it's not aware of the context. People make decisions observing many things around their background, history. There are many more information there. So that's why it's very difficult that a machine learning tool is making an explanation in terms of causality and trying to explain why things happen. Because many times the right explanation is out of the data. There is something else that is around that you don't know because it's not present in the data. So in that sense, the judges, you refer to the name of the judges, the name and the gender. And you observe that because of the record of this judge, how he was doing the decisions in the past, you can have an idea about if this is more trend to go to one verdict or another. I'm not sure if this is good for prediction, or if this is fair to do the prediction on that. And probably if you are thinking in forecasting, it's better to try to see a profiling of the judges and try to see if there is something in the definition of the whole profile of the judge that there are some things in common, and that in the future when you have a different judge that is different from the one that you have in the list, you can see if this judge is similar to any of the others that you have studied, and you can try to forecast a similar decision.
Yeah. I think they're excellent comments. I'm just thinking about, so when you say, so I agree with your comment on artificial intelligence and machine learning, right? So you can even doubt the whole idea of intelligence in this respect, right? So, and again, so we use machine learning, but we use data. They're like use data science, machine learning, artificial. They're used all the time, and they're not the same. So I completely agree. So then your question about like the corpus we're using, right? So the English language, which they're all different type of corpora we use to train the machine. So now there's even a legal words corpora where we can train with specific legal text. They're in English, but they're also available in Dutch and also Spanish and French. So we will use that. So we work closely together with the computational linguistics department. That's also specialized within using different languages and data set with languages. And we're not using the English corpus and then translating the Dutch ones into English, and because you're completely right, that will bias your results, right? Or that will impact your results. But it's a good thing to remember, and what's also probably then our data set can also be used to further develop the legal word corpus for legal research, right? So that's what we are doing. Then the second thing, I'm not sure whether I remember your second point. Yes, so that you say, so for example, using names of the judge, and that's a good prediction. I think we should be very careful in just focusing on machine learning and then using that type of data and information and findings as the main finding of your research. As I said, we combine this with different research techniques and also use more contextual, comparative legal research, doctrinal legal research, content analysis where we use with scales. But this is a type of information we can use in, for example, making sense of why the court decided in this way or another. Or you can, for example, see whether this right to housing had any impact in the reasoning of the court. If you see that words associated with the right to housing or the right to child pop up within this case and they seem to have an impact on the decision, it might be a good indication that there is some impact of the right to housing, but it's not a causal relationship, right? So that if this word pops up, then the right to housing had an impact. Because it can also be decorating your judgment with just fancy words or referencing international case law or international rights or legislative treaties, but without it having any impact, right? So it can be different things. So therefore, you should always combine this machine learning and analysis with other types of techniques. And that goes wrong in many of the papers that I presented today, because they're only computer scientists and they're just saying, okay, we found this correlation, and therefore we established that there is an impact of this right on the decision making, which is not a valid conclusion.
There is something very important that is in the point of trustworthy AI, and I'm working in trying to build a model that are interpretable and explainable. This is another discussion for Andrés. What is the point between transparency, explainability, explainability? There are a mess sometimes with education. But anyway, the point is that you have the model that you have built. There is a problem with language, with low resources language, for example, with the Galician language, with the Scottish language. They are underrepresented versus English, French, Spanish. So people should take care about this and not having high expectation because there is artificial intelligence. This is magic and this is solving everything. So there is a magic for education. I'm working in artificial intelligence in general, but with different domain topics. When you go to talk to a physician, when you go to talk to a lawyer, when you go to talk to different people with different profiles, you need to explain them which is the benefit of using artificial intelligence, what are the pros and the cons. And then I strongly believe that is a tool for assisting, for helping, for decision-making assistant, but not for making decision itself. In the sense that I think it's better if the judge have a tool that is providing a lot of information in a clear way, say here you have all the information, now you make the decision. Because you can do a more informed decision with more information. But the point is to be sure that you understand this information and that you can use it in the right way. Because before we have statistics, and you have a lot of statistics that you can see a lot of feature, and this is also making a help, but at the same time, depending how you look at the graph that is representing the information, you can be prone to one decision or another because you are confused or misleading because of the way how the data is presented. So now when we go to machine learning and all this stuff, I think the main problem is with the expectation that people have because the machine seems to be clever, so I have to meet the decision by the machine. And this is what is risky and it's related to the comment that you have today. AI, conversation, we were organizing, I'm working in CITIS, that is the Research Center in Intelligent Technology, in European project on explaining artificial intelligence. We having many discussions about the act and the potential implication.
So I think that's an excellent comment, but I think it's important to notice that you're working on using algorithms, looking at data and not even legal data, and that has some practical use and that assist or that assist the decision makings or are decision making tools themselves. I'm not interested in building a tool that assists judges to help them with eviction or the European court helping them to decide whether there's a violation or not. I think the tools we build are not useful in that respect. What I'm interested in is in the identification task, is building better data sets. That's basically helping researchers, but also practitioners finding interesting cases among the tsunami of case law. And the second thing is finding the good predictors and making sense of them as a researcher to better understand what's happening at the court stage. When I find good predictors, I don't consider them to be causal relationship, right? So because there's more context than the textual features that I find, or the other features that I find. So we need other research techniques to make sense of the data. So that's basically, so I'm not interested, we actually at the Jury Says website, we also link to the ethical piece. We're against using this in a practical way in high stakes situations. So maybe in a rent control case, and that also answers the question where you said in a practical use, can we use it? Yes, so I think it would be great to use it in a rent control context. And if companies, like lawyers, that use that in tax law cases, right? So I'm not really against using that, but I'm also not like an expert in like what are the stakes in these commercial things. What might be an option is, we wrote a short paper on like, it will reinforce the theory of calendar. Maybe you know that of the haves and have-nots. So you have people that are the haves, that have all the legal knowledge, that have the power, that have the opportunity to go to lawyers, specialized lawyers, and you have-nots. Who are usually people that go to court once or twice in their lives and don't have the power and the knowledge to understand the law and go to good lawyers. And this will reinforce that difference, right? So the haves, companies, landlords, governments, they're the haves. They can build this type of data sets, they can build this type of algorithms, whereas the tenants, laborers, like the vulnerable people, they don't have the organization to build the data set because it's scattered all over the place, and to build this data, to build this algorithm. So that's interesting, I think, from a legal perspective, and also from a political science perspective. Who has the power to build these algorithms? So usually they're not like the tenants, lawyers, or the lawyers that used to represent the tenants. They can build this data because they're scattered all around the country. But the lawyers of the landlords, they can build this type of algorithms, which is an interesting perspective. Then I only have one question left, sorry for talking that long. It's about the French debate, about banning these techniques. Yes, I'm aware of this French debate. What we did with Yuri is illegal in France. I think this is a clear violation on Article 10 of the European Convention on the freedom to receive information. So that's the point you made as well. So I think it would be interesting if French legal scholars are going to complain about this whole ban. Right? So I understand the ethical concerns, because basically this was about a project about immigration law or migration law, where French judges were being framed as you're pro-immigrants or anti-immigrants. And it was basically that. So it was basically about like naming and shaming judges, which is not the same thing as we are doing. But still, we published a paper about the European Convention on Human Rights judges. We even added some figure about like which judge is associated to violation or not. I think in the next paper we won't do that. And when we got the ERC grant, we also had to write a very long ethical report, because as a lawyer, we're not used to write this ethical report, right? So we just use case law, which are publicly available. And now we use a different type of data. So, for example, the name of the case now is more problematic. So in traditional legal research, we just say, okay, it's Miss Gonzalez versus Spain, and that's no problem. But here, it's when we use it in our project, it's considered to be personal data. And we cannot refer to the case as Miss Gonzalez versus Spain. But at the same time, that's weird, because then I say, okay, I have this Spanish case and nobody understands what the case is about. So we need to we had to take into account all kind of ethical concerns. One thing we did is that we're not going to publish the data set right away on the website, but we're only going to publish aggregated data. So where we say, so we found 60 cases about Roma people, 80 cases about health problems, but you cannot identify like the specific case where we said, so this case there is a health issue, or there is a gender issue, or a minority group issue. And we're still struggling with that, because we really want to have open data and to share it as much as possible. At the same time, for lawyers, it's also new to see your legal data with this lens, right? So where there are all ethical issues come up. Okay. So did that answer your question?
Yes.
Okay.
No, and in fact, the lawyers of the tenants and the lawyers of people with no possibility of the landlords and tenants. It's interesting because maybe part of the reason of the French ban is also to try to avoid that kind of inequalities. Well, I don't know, because I am not aware of the French debate in depth. Maybe that's part of the reason, because there's a connection. Well, so thank you for the questions to everyone. Pablo, I also agree with you that at least That's a state-held information, at least. I would say that's more than that. In fact, I've written that, in my opinion, if a public administration is using an algorithm in order to decide issues, it's exactly the same function as a traditional regulation, and that has to be considered like that. And maybe it's not exactly the same legal framework that we should apply to do that, but the basis of this legal framework should be exactly the same or equivalent, because the function is equivalent. So I completely agree with you, but that's the minimum. That's the, in my opinion, that should be the point of departure. The problem is that, in my opinion, it's not so important. And for the moment, European judges and national judges are not considering that. And they are accepting that that's not state-held information, and that a lot of exceptions, even if that's a state-held information, because in some cases clearly it is, for instance, the Moscow issue, even in those cases they apply some of the exceptions, for instance, security or intellectual property rights, with a lot of generosity. So that's the situation that we have right now. Regarding your second question about discretion, I do not agree. Because I think, well, Michel said that there are different kinds of discretion, and I think that's it. Because we have to consider that it's not, I would agree with you when we speak about discretion relating to a political evaluation, assessment of a situation, or when we have elected someone in order to decide among competing values or competing opinions. But in other cases, discretion is about an evaluation and assessment of a situation and to extract some consequences from that. For instance, Diogen, when Diogen says, I have a higher risk here, and therefore we need more protection for that woman, that's a discretionary decision. In a traditional system, is the police in charge in your city who analyze the situation, and according to his or her experience, or in Spanish we say olfato, I don't know in English, the savoir-faire. According to his or her savoir-faire, he or she decides that's a risky situation or not, and that's discretion. The thing is that right now we have systems that have the capacity to make that decision better than the police officer. Or maybe not better than the best police officer we have, but better than 80-90% of our police officers. And that's why we rely on those systems. And that's why we rely on Diogen. Even though, obviously, we have a lot of problems and a lack of transparency, but the system works. And that's why the police and the Spanish police, after 15 years, relies more and more and more and more on the system, because they have more or less the evidence that the system works. And that's a discretionary decision. According to the German law, in Germany, it's impossible to do that. Of course, they bypass this prohibition by saying, wow, but it's not the algorithm who is making the decision. It's a police officer that, using this information, but also other information, is who's making the decision. But that's a way of bypassing the decision that may work now, but in the future, or when we have data that shows that, well, theoretically, he's using this data, but also other instruments. But if we have data that 100% of the times, the police officer decision is exactly the same as the prediction or recommendation made by the algorithm, well, it's clear that de facto the decision is being made by the algorithm. So that's why I consider that the German solution is not a solution that is going to be possible to maintain in the future. Or it's only possible to maintain that solution in the future if we gamble the definition about what a discretionary decision is, or if we cheat saying that the decision is going to is being made by a human when it's not. So that's why I consider in that kind of discretionary decision. Of course, I agree with you with all the discretionary decisions where the key issue is a conflict between different values, where we elect someone to take a position. Regarding Biogen, because I use Biogen as an example, I have not the data about the resources invested in Biogen, but according to the information I have, the resources invested to Biogen have been independent of the money that they have for gender policies. Why? Because it was more or less isolated, because that's a police tool used by the police. And the money cuts were essentially in social treatments and prevention, etc. And also because that's the rising star of the system from the prevention policy. Because they, at the beginning, they have the money to begin with, and they discover that they were satisfied with the tool in the first years. So that's why they have had no problems of money to develop the tool.
No clarification. I wasn't pointing to the money put in the Biogen, but the money put in the policy. Because if Biogen makes a decision whether to protect or not, I assume it will be affected by the resources you have
Yes, of course.
and the amount of people you can protect. That's what I meant.
Yes, sorry.
Policy is shaped
Yes.
by them.
So of course they have limited resources because the number of police officers they have is limited. But as you know, in Spain we have cut in almost every domain of administrative works, with some exceptions, and the police as well. So they have a limited number of police officers, but that has not been an issue. The interesting thing with Biogen, I think, is that they rely more and more and more and more on the system, and they have different fixes regarding the technological part of the system. But the system relies on data, and data are supplied by police officers and social workers that they have to fill in a form after the conversation they have with the possible victim. So a lot of resources during the first years were poured in the algorithm and to try to make the algorithm better, and they neglected they didn't see at first the importance of having well-trained people collecting data. But beyond a certain point, they detected that, and in the last years, they have made a huge effort trying to standardize the questionnaires, give a lot of elements of analyze to the officers in order to try to avoid the risk that you collect data, but you don't collect them well, and you have problems. There are other problems with brain testing. It's a very complicated. It's complicated to get data because that's not medicine, where you have a scan and you have data with, for instance, they have also problems with the language of people, and that is related to vulnerabilities, because it's not the same when you collect data from one person who doesn't speak Spanish, because she's a migrant, and she may have problems communicating things, and that would have a reflection on the quality of the data, the quality of the questionnaire, etc. And it's even not the same when the person is a native Spanish speaker or a native speaker of one of the other languages of Spain. Because some parts of the questionnaire are heavily dependent on linguistic constructions and how the woman express things, because so in some cases there are a lot of things to fix. That's clear, and with more words it's easier to fix that. But I think that has been a priority, and it's still a priority. And the evidence that that's a priority is that they want to increase the use of biotin to not only protect women but also control possible areas. Mireia, your question, I think that your question is really interesting. So I agree with you that, and I have to confess that I didn't reflect on that before you asked. But I think you're right. Explainability is maybe a necessity, but maybe it's not enough, and we also need, I don't know if the complete database that is something that we have to put at disposal at the disposal of people. But I don't know exactly how to do it. The only thing is that I consider, and that's something related also with the answer I'm going to give to Michel, that it's not a drama to go step by step. So for the moment, we do not have enough explainability, and we do not have even the source code. So, well, that's the priority. It's possible that that's not enough, but well, that would be something better than what we have. So little by little. But it's clear that we will need also the data, or at least a database worked like the database that you said that you without the personal data, etc. But we will have to analyze those. And regarding neural networks, well, that's something related with machine learning and how artificial intelligence evolved. According to my knowledge, maybe in past years we have something else, but according to my knowledge, the most important conference regarding artificial intelligence and how to control that was the conference held in Asilomar in 2017 with all the experts in the field around the world. And the problem they faced were more or less this: how we can control artificial intelligence beyond the point that we have no capacity to track the system only using the source code and explainability, because that's not enough, because the artificial intelligence with neural networks, beyond a certain point, you cannot control the output. And what they more or less agreed on was that, yes, that would be a problem, but this problem will be even worse if we do not have at least the source code. So the first thing is that we need the source code. And if we have the source code, we can at least analyze how this artificial intelligence was designed, and for them it was especially important a clear definition of the goals, the aims of the system. Because according, I am not an expert, so maybe you know, I am sure, better than me. But according to what I read, they explain, in those cases in which you risk losing the control of the system, it is essential that the definition of the goals, the instructions you give to the algorithm saying, I want to achieve this and this and this and this, and these are the goals. And this is the balance between different goals. And this is the priority. And the second priority is this. And if there is some conflict, that is the most important thing, etc. It's really important to have that defined. And you define that in the source code. So in order to audit that from the outside, that's at least what we need. Having said that, maybe we can establish a kind of precautionary principle in this area and say that public administration, public powers, especially regarding the rights of citizens should not use that kind of algorithms, at least for the moment, at least when we do not know exactly how to control them once they have evolved. Because it's not a dramatic thing for public administrations not to use the most advanced possibility in algorithm and neuronal networks that the technology could offer. So I don't know if that more or less answers your question.
Final question?
I was just to go on with his comment because I think it was 2016 when it was the first time that deep learning started to be ready in the board because neural networks are from the 80s, 1980s, and they created expectation, but there was no hardware, there was no way to really exploit neural networks. So there were many expectations, and then people was frustrated. But around 2016, there was a competition on image processing, and it was the first time that a neural network, a deep neural network with many layers, was able to be able to produce better results than a human. And afterwards, people say, well, something is here, because if this is powerful than a human, and we can use for image processing, but also for machine translation, for many other things. That's why people start to use more and more, also because there is a matter of hardware. It's called promotional neural networks, and Google have many machines that are devoted to that. So they start to use more and more, and that's why nowadays we have all people talking about artificial intelligence because of the success of those applications that should be intelligent. But then it comes to the other side of the coin. They are black boxes, and you cannot trust them. So that's why since maybe 3-4 years ago, transport for AI started to be more and more important, and all the regulation and all this stuff. So what is the point with deep neural networks? The more layers you have many neurons in the network, and they are all connected. Even if you know the architecture, because there are different architecture that you can use, that will be the soul. You have the architecture and the parameters that you use to initialize the algorithm. But then after running, depending on the data that you use to fit the model, you have the final model that is built. And what this works is that if you repeat the experiment several times, you don't get exactly the same number. This is a problem of reproducibility of the result. And this is what is making people, even data scientists, not rely on 100% of this kind of model. So it's not a matter of having a source code where you can see if this happens, do this, if not, do that. It's that at the end, the model itself that is making the prediction has many random weights inside that is making the connection of all these random weights and what is making the final prediction. And it's said that in most of the cases it's working well, but for some specific cases, then the output makes no sense at all. And when this happens, you don't know why, and you cannot explain why. Then we have to problem. That's why I agree with her that it's not just a matter of the source code, but it's very important the data that you use and the reproducibility of the algorithm. And now, for example, in the academic, most journals are asking just to upload the paper, but also the data and the scripts and everything that you do in order that at least repeating exactly the same experiment, you can see that the numbers in the tables in the paper are right. Because before I could say, these people seems to do something similar to me. I'm going to try to repeat the experiment with my own software to try to compare. And it was almost impossible to reproduce the same result. So that's a mess, and it's a problem for science, for advanced science. So I agree that having the source code is important, but I think that it's very important what you say about auditing. Probably, I don't know if this needs to be a public or a private company, or this has to be independent external auditing body. But this is in agreement with the artificial intelligence ethics guidelines. You were talking about soft law. Well, there are many things about it. The high level expert group was proposing guidelines. And if you look to the guidelines, this is like having a form with many checking points. And then it's needed, you can try to make something automatic, but in most of the cases, it's an auditor that has to go there to look to the source code, the model, the data, what is there, and establish it. This is valid, not valid, 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 not valid. And then at the end, you have to say if this model is trustful or is not trustful. Like you have an auditing for security, for example, or an audit. So I think that we should go toward this direction, because at the same time, if you put just the source code open in a web page, for example, for me something like the transparency portal that we have with the e-governance, where you have more and more data, but at the end you are creating noise, and not everyone is ready to understand and to interpret this data. And this is a problem too, because at the end, you depend on having engineers, mathematicians, people who is able to go to the source code to understand what is doing. So we are creating like entities and a difference between different type of people. So I agree that it could happen that the people who is making the auditing, they are paid and they are not doing a good job. But this is another matter how to regulate this. But if you have these people who know how to do the checking, the auditing in the right way, and they have signed confidential agreement or whatever, so they are respecting the professional, the property, intellectual property, they can access to the model for sure. If the company is investing a lot of money to develop some algorithms, they are reluctant to share. Another issue is if the model is developed with public money, and we have public projects, and they say, if I'm funding you with this, you have to advertise the funding, and for sure you have to publish in open source, and all this stuff. I think that we agree on that. So only just to make this remark, and the discussion between interpretability and explainability. Many people in data science are for interpretability, for transparency. That means that I can give you the model, the shortcut, or just the model, the network itself that is generated, and you can look to it and try to understand how it works, because the model itself is available. Another issue is explainability. And for me, in the project that we are working, the idea is to put explainability on top of interpretability. So the point is, if a human is able to look to the interpretable model, to make an interpretation and to provide you an explanation, it is possible to do this in an automatic way. It is possible that the algorithm itself is just providing the explanation and is explaining, is this because of this, or this, or this, and it's not this because of this other thing. That is very challenging. It's something that we are exploring now with the counterfactual explanation that you were referring to. But I think that's a good direction to try to provide more.
Okay. Well, thanks very much for everybody being here, for the rich debate, for the magnificent interventions. That's the end.